Yes. Against.
Item number 1, my lord, this is for correction. Your lordship, kindly page 5, your lordship, there were two judgments, similar judgments. One relied upon by the state, one relied upon by the respondent. The WPST now number
What
7.
is the error?
Error, my lord, page 5,
Huh.
the second paragraph, last line, it is WPST 77 of 2023 has been mentioned. That will be WPST 71 because that was the case which was relied upon.
Please write it down. It will be WPST 71
71
of 2023.
23 and the cost title will be different. I am stating that.
আচ্ছা লেখো by reason of a typographical error in the first third fourth paragraph number what is the paragraph number? Have you
So first paragraph, your lordship, because page 5.
no what is the only one place the correction will
Yes,
go?
yes, only one place. The rest of the judgment is already.
By reason of a typographical error in the first paragraph of internal page 5 of the order dated 7th of February 2024 by reason of a typographical error in the last three lines of the first paragraph of internal page 5 of the judgment dated eto the name of the WPST application has been erroneously incorporated as এখানে যেটা আছে সেটা বসিয়ে দেবে WPST 77 or 23 bracketed state of West Bengal and other versus Obijit Acharya Bhaduri and others in place and stead of quote unquote দিয়ে দেবে WPST
71 of 2023 state of West Bengal versus Shubhendu Bhattacharya and others. I am handing over a
the other
copy.
portions of the order shall remain unaltered. This rectification shall be deemed to have been incorporated in the order dated such and such 7th February 2020. Urgent for
I am extremely grateful.
ওনাদের নাম
আমি একটা 71 এর কপি দিয়ে দিচ্ছি যেটা অ্যাকচুয়ালি রিলেক্ট করা হচ্ছে।
For the writ petitioner respondent.
Saurabh Kumar Mukherjee. I'm led by Mr. Saurabh Kumar Mukherjee, man. He is in online, man.
what is
Of interim. Assigned matter.
Is it appearing in the list?
Today list, my lord.
No,
Today list is
under the heading assigned কি এটা ঢুকে আছে? What is the name? Doctor.
It was not appearing in the list, my lord. Thereafter, they mentioned, my lord,
it was
for
mentioned
extension
on
of
19th month.
Same matter টা দুটো জায়গায় appear করছে। To be mentioned দেখো MAT 2094 item number it is Sunanda Goenka. It is not in the
My lord, it is not in the list. That's a different appeal, my lord.
that is a separate
Separate appeal, my lord. The interim.
now affidavits are complete.
My lord, the
Affidavits are
state
complete.
respondent, the state respondent, on the last occasion, the state respondents bring time to file their opposition. My lord, till date, I have not received any opposition from the state respondent, my lord.
Mr. What is your name?
Falguni Jana.
Who?
The appellant is Dr. Sunanda Goenka.
We are asking your name, madam.
Miss Falguni Jana.
Miss Jana. learned advocate appearing for the appellant submits that in spite of an earlier direction, no affidavit in opposition has yet been filed by the state respondents. Yes, you are for the state.
I am for the respondent number 1. Did petitioner responded, my lord?
You have filed the opposition.
No, my lord, I will file.
You have also not filed. In spite of an
My lord,
earlier.
my lord, may I assist your lordship? The petitioner perhaps is under some dilemma. They have already filed their affidavit in opposition. The petitioner has already filed their affidavit in opposition, and we have filed our affidavit in reply thereto.
You have filed.
No,
I have filed my affidavit in reply to the affidavit in opposition of the petitioner.
Further extension of the interim order, which is due to expire on 29th February 2020. Stop. Let the affidavits exchanged by the appellant and the respondent number one,
One.
as filed, be kept on record. Stop. List the matter for further consideration. In the daily supplementary list of this court on 19th March, stop. The interim order passed earlier is extended till the end of March 2024 or until further orders, whichever is up.
Grateful, my lord.
I'm grateful, ma'am.
grateful.
May it please your lordship, my lord. But this is the affidavit of service, my lord.
Who is your other side?
My lord, I don't know, my lord. Yesterday I have served to the learned government leader, my lord.
They have to
And
be-
that has already been given to the Sarthak also yesterday. That has already been given to the Sarthak also.
Who is the council engaged? Do you know? You must be aware. You are in that group. I know. Stated
Long back, my lord.
My lordship, Mr. Galib is for the state.
You are appearing?
Mr. Galib is
Mr. Galib is for
Where
the
is
state.
he?
My lordship, he is engaged in code number 6.
Ask him to come. Pass over. Or come tomorrow, Mr. Dutt.
no, my lord. Today is the date of demolition, my lord.
Pass over. Yes, tell Mr. Galib to appear. Yes.
I have filed the affidavit of service. my lord.
নিয়ে দিয়ে দাও না এভিডেন্স সার্ভিস দিয়ে yes
My lord, item number 4, I am appearing for the petitioner, my lord. The affidavit of service taken on record. My lord, here the land in question is of my father. My father passed away. Thereafter, me and my mother became the legal heir of the property. My lord, I applied for mutation before the concerned authority. They did not consider the application. My lord, I went to the LRT. The LRT said, you go and file the application in proper format. They will consider that. They passed an order in this regard.
when was that order passed?
My lord, that order was passed, that is in annexure P2, para number 13 to para number 14. My lord. Page number 13 to page number 14, my lord. My lord, that order was passed on 9/11/2017.
That was an earlier way. That was disposed of,
The OA was disposed of.
giving you liberty to
File afresh before the.
file. Then what happened?
My lord, I filed afresh, my lord.
When did you file?
My lord, I filed on 27/2/2023.
Where is that?
My lord, that is in page number 15,
1-5.
15. Annexure P3.
1-5 is P3 is a death certificate.
My lord, subsequent to that, my lord.
Yes, page 16. When was this filed?
My lord, this was filed on 27/2/2023.
How will we understand? There is no receipt given.
My lord,
10th of February 2020.
10th of February
So
2020.
you filed it after 5 years.
My lord, in the meanwhile,
No. Order was of 2017.
order was of 2017.
So you were asked to file a giving grant liberty for application. Very good. Now you applied after 5 years. Then what happened?
My lord, in the meanwhile, my mother passed away. So I became the sole legal heir of the property.
When did your mother expire?
My lord, my mother expired on
6th of May.
6/5/2016.
So from 6/5/2016. Then how did you move the application? Oh, it was of 2014.
It was of 2014.
Now then what happened?
My lord,
Then it was not considered, you went to the tribunal.
I again went.
Now what do you want from us?
My lord, the only thing that I want is, my lord, I have filed it in 2023. The first hearing took place on 13/6/2023. Subsequently, my lord, the next date is fixed on 12/4/2024.
Hmm.
My lord, almost after 10 months, my lord. I've been trying to mutate a property for like 7 years now.
So what is, sir, you yourself created the delay.
My lord,
You did not apply instantaneously.
my lord, kindly appreciate, my lord.
Wait for that.
To the state.
My lord, kindly appreciate one thing. My lord,
Have you
on the
got the current record of rights?
my lord, the record of rights, my lord, the record of rights are annexed.
To which you are seeking rectification?
My lord, the record of rights, yes, I have got the current record of rights, my lord.
Page number?
My lord, page number 18, 19 and onwards.
Page number 18, 19.
18, 19, 20, 21.
On 13th of June, BLRO was asked to file a status report.
Was asked to file a
And the
statement
matter was fixed on 12th April.
on 12th April. My lord.
Now, in the meantime, it again came up on 13th December.
My lord, we mentioned the matter. We had an informal talk with the government advocate, my lord. They are also ready with the report. We also had some additional documents to file, my lord. We were ready. We mentioned the matter so that it could be heard early.
Have you filed the additional documents?
My lord, we have filed the additional documents. However, the learned court said to comply with it again in terms of the order dated 13/6. So, my lord, the matter would be taken up. The matter would be heard on 12/4, my lord. I humbly pray that the matter may be heard expeditiously, my lord. That's
So
my
it will be hard on 12th April.
my lord. Sometime sooner, my lord.
No, already. Date has been fixed. If on that date court does not hear, then you take appropriate steps. How can we, this is we cannot pass an infructuous direction. We don't know what is to happen on 12th of April. You have not filed additional documents. Status report has been called for. Tribunal has proceeded. What is the infirmity?
My lord, there is the only humble prayer is, my lord, the date may be fixed.
Our humble statement is you withdraw the application. There is nothing in this. Appear before the court. Okay. Withdraw this application and fight out the matter on 12th April. If we reject your application, that will not be good for you.
My lord, then I have to seek instructions. My lord, kindly keep this matter on the next date, my lord. I'll come up with instructions. If, my lord, I get instructions to withdraw this matter, my lord.
Come to be mentioned Tuesday. আমরা অ্যাপ্লিকেশন এই ডাব্লিউপিসিটি গুলো কবে নিই? মঙ্গলবার নিই তো? হ্যাঁ, তো মঙ্গলবার টু বি মেনশন। আচ্ছা, in course of hearing, the learned advocate appearing for the petitioner prays for an accommodation to avail necessary instruction. Mr. Chatterjee, learned advocate, enters appearance on behalf of the state respondent. Stop. Please the matter for further consideration under the heading to be mentioned in the daily supplementary list of this court of a date the other. 5th March, 5th March to be mentioned.
Grateful.
Affidavit of service file we kept. Yes, sir.
My other side has come.
Land manual 66.
Hey.
Sorry,
Milord, for being unable to attend the first call, Lordship.
My lord, the impugned order dated 19th of February 2024
yes,
My lord, impugned order dated 19th of February 2024 is before your lordship. My lord, kindly have a look at page 113. My lord, prior to placing this, my lord, the impugned order, may I be permitted to place the facts so that, my lord, it would be clear before your lordship, my lord?
yes,
My lord, on 16th of October 2023, my lord, a public interest litigation has been moved. An honorable division bench of this court has passed an order. Kindly have a look at page 66.
is there any private respondent in the matter?
No,
Achha.
page 66.
Yes,
My lord, it starts from page 66. By filing of a writ petition, the petitioner seeks the direction upon the respondent to take action for the preservation and the restoration of the land in question, and the original nature and the character of the Sali, Doba, and the Khal, recover the cost of the restoration of the private respondent and the affidavit in opposition and reply such and such. Learned counsel appearing for the petitioner submitted that already a notice under section 4C5 of the West Bengal Land Reforms Act of 1955 has already been issued, but curiously enough, the authority has not proceeded further, citing the pendency of the writ petition. We reasonably come to a conclusion that the statutory authority, under the guise of the pendency of the writ petition, appears to be colluding with the private respondent, is not the taking steps in the logical conclusion. However, the authority, after having been satisfied that there is a prima facie violation, has issued notice under section 4C5 of the said act, and therefore the authority should have proceeded further undertake the matters in the logical conclusion, and if the authority fails to do so, an action would be taken against the authority. In the light of the above, we direct the concerned authority to complete the proceeding initiated under section 4C5 of the act and take the matter to its logical conclusion by passing the reasoned order in accordance with the law. This is the principal order. Subsequently, observation has been given. Should I place the rest of the portion? Yes. Kindly have a look at, subsequently, we have moved a review application appearing at page 76. Got it, Malak?
yes,
The review application has been filed to review the order of the direction dated 16th of October 2023 in WPA number such and such. We have perused the order. We found that the only direction given was to the concerned authority to complete the proceeding already initiated under section 4C5 of the West Bengal Land Reforms Act of 1955. After the notice, all the respondents, including the review application, were heard in the matter when the writ petition was disposed of. Thus, we find that there is no error apparent on the face of the order to exercise the review jurisdiction. It will open to the review applicant to raise all issues before the concerned authority in pursuance of the proceeding initiated under the West Bengal Land Reforms Act of 1955. On the basis of which I made a my lord comprehensive representation. Kindly have a look at page 78. My principal prayer is this, my lord. This is a case, they have initiated a proceeding under section 4C5 because the no conversion, there is a DOBA. Without taking conversion, I have constructed the building. My case is this, my father had been residing over there prior to 1980. So therefore, I would not be amenable under the 4C5. No correction is required. Only post facto conversion is required under the rule 166. So, my lord, I have made a comprehensive representation. Kindly see the paragraph number 1 at page 78. The father of the undersigned, namely the late Nirmal Kumar Sardar, being the residing in the plot number such and such, constructing earthen structure prior to the year of 1980, as evident from the property tax paid by him on the March 24, 1980. So this was German before the authority. My lord, I have submitted the document. Kindly have a look at page 36. What is the document, my lord, I have relied upon? Page 36.
Yes.
My lord, may I be permitted, my lord?
Yes.
My lord, kindly have a look at page 36. What is the document on the basis of which I am claiming? Page 36, my lord, this is a tax, although this is illegible, that has been issued in favor of Nirmal Kumar Sardar, that is my father.
That has been disbelieved, Mr. Dotto.
My lord, kindly have a look at it. Kindly have a look at this. They cannot disbelieve. Kindly see the two documents I will, my lord, furnish.
Yes. How does that establish your right to the property? Payment of tax is a consequential issue. We do not know who obtained.
My lord, kindly appreciate only the single thing, my
No,
lord.
Mr. Dotto, you failed on that count before the review petitioner. You could have sought for at least expansion of the remarks that the division bench.
My lord, nothing prejudicial. Kindly see,
It's
nothing.
prejudicial. Court came to a conclusion that the state authorities in collusion with you is not proceeding. That is a very serious allegation, Mr. Dotto.
My lord,
In review petition, you ought to have prayed for expansion of such remark.
my lord, kindly.
That you hear me when you are passing an order to consider all my parts. Then you keep that direction in abeyance.
My lord, kindly appreciate.
We are asking a question to you, Mr.
Yes,
Dotto.
yes.
When the division bench has come to a conclusion, it's a serious observation.
My lord, may I
In
submit?
review, that has not been altered.
My lord,
All your case matters have been asked.
may I submit, my lord? Two aspects are there. The my lord, who is the writ petitioner before the my lord, before the honorable division bench?
It's public interest litigation.
No, this point has been, my lord, agitated. He is my lord, the Borgadar. He is a primary teacher claiming to be the Borgadar. In his personal interest, he did so. I have brought the fact to the notice of the court.
What did the court
Court said, my lord, court said, since, my lord, this is a proceeding under 4C5, you are agitating a point that you have been residing over there. So you would not be remediless if we approach the authority, furnishing all these relevant documents, and the appropriate authority will take a decision on the basis of this. So it is
decision
not
has
the
been
collusion. It is not the collusion because, my lord, behind my back, my lord, this order has been passed. Kindly appreciate, my lord.
Which behind your back?
My lord,
Which order?
the order which has already been passed. Thereafter, I have filed a review application.
Yes.
I have filed a review application. In the review application, it was fallen from the court. I have agitated all those points that I had been residing over there since such a period of time, and I am furnishing document. It is not the ownership. It is that
thereafter you submitted a comprehensive representation stating that in 1980 my father deposited a tax to the Panchayat authority. Now ADM thought for a report
and kindly see the reports.
dispute the authenticity of the document.
They cannot be, my lord.
Your father deposited tax in 2000 in 1980, and you made application for conversation in 2023.
This is not a case of, this is wrongly advised. This is not a case of conversion, my lord. This is a case of post facto conversion. My lord, kindly have a look at.
Yes, but ADM and DLRO has held that here The manual of 166 has got no application.
Kindly have a
166 of the LR manual will come in respect of where the land has already been by gradually, without intervention of any human being, has been converted.
kindly appreciate.
Then it is here that it has been already converted, or if it is converted by my predecessor interest since long back. So now give me prospective conversation.
I beseech before your
And
lordship. Kindly
we have made this application in 2023, relying upon a document that of
Milord, perhaps I am not clear.
1980.
Milord, perhaps I am not clear to your lordship, Milord. Kindly see the order, which has been two portion of the order is this, which has been challenged before the way.
Place rule 166.
Kindly see. Where the conversion has been made before making application
That does,
permission.
Manual
Manual.
166.
166 manual.
Where conversion has been made before making
book is needed.
application.
Big book is needed.
এটাতে
One leaks things. It are the only sections are there.
No, in section that can be clear.
45 we rule 166.
No.
Manual. Manual.
3814 আছে। No, what you are
Milord, this is West Bengal Land Reforms
No,
Manual
we have got-
1991.
what is the title of the rule?
Title is where conversion has been made before making application for permission.
Yes. Now please.
While disposing of a petition for conversion, it may come to the notice of the collector that the land has already converted to some use other than that appearing from the record of rights. Such a case and the should normally be dealt with under section 4.4. In such cases, it should be inquired as to whether change in use has been made in the usual course of the nature or by deliberate action on the part of the applicant or any other person, and in the latter case, it should also be ascertained whether the change took place before 24th of March 1986, the date of the publication of the official gazette and the West Bengal Land Reforms Amendment Act of 1981.
Yes.
So, my lord, kindly have a look at the document.
Now come to that.
The next
Come to the
portion.
next paragraph. There are three
Well,
or
clauses are there. Kindly see.
3 or 4 contingencies, conditions where
No, subsequent.
166 will be invoked.
My lord.
If the change is in the use of the land
Milord, kindly allow me
has
to read.
occurred, act. Yes.
If the change in the use of the land has occurred in the usual course of the nature or has occurred at the time when the such change was not unlawful, has occurred due to the development activities of the government or the local body in the surrounding area, and due to the urbanization on the surrounding area, the applicant should be informed that the change is being noted in the record of rights, and the said record and the should be corrected accordingly in the due course. If there was a reasonable cause made behind the change of the occurred, the collector may consider the merit of the case if prospective permission should be granted. In the connection of the expression without any reasonable cause, in section.
So there are
No, otherwise, third one also important.
Yes.
Kindly see. If it is appended that there may be many cases of the unauthorized change of the land use where no application for the permission to make such change has already been made, the revenue inspector shall make inquiries. It is the obligatory on the part of the authority to conduct an inquiry regarding such unauthorized conversion during the prior tour of their areas, if any such case has come to the notice that the penal section such and such.
Yes.
So, when I make an application invoking 166, it is obligatory on the part of the authority.
No. Whether the condition to invoke 166 are fulfilled or not.
Milord, kindly appreciate.
When the land is converted on foreground, where in usual course of nature, that means there was a pond. In usual course of nature, it has converted to a land. B has occurred at the time when such change was not unlawful. C has occurred due to development activities of the government. D due to urbanization in the surrounding area.
Milord, may I submit?
Now,
4 contingencies are there.
now
But it
say under which contingencies you have placed from.
Milord, kindly have a look at. Milord, the difficulty is this. In the initial section, it has been already been mentioned that I have to prove before the authority that I had been residing over there prior to 24th of March 1986. If I stay over there, because it is quite difficult for me, I being a son, to demonstrate before the authority, saying,
There you go. Land deposit. Land deposit.
Milord, it is quite difficult, I being a son, to say as what condition my father was residing prior to 1980. It is completely, Milord, not conceivable that I would be, because my age would be 10. When this, Milord, I had been residing over there, I would be 10. So, Milord, only
It was incumbent upon you to immediately approach the authorities. This is a backup case which is being argued by you.
no, Milord,
It's Rule 166.
Milord, kindly appreciate,
No,
Milord.
we are hearing. You listen to us.
My lord.
You filed you admittedly you did not file any application seeking the benefit under Rule 166 since 1986 till date.
Milord, it is not.
Period. Kindly consider
My-
86. We are now in 2020. You are running a hotel business.
No,
And
it is my
you have-
residence, part of my hotel. It is also residence, part
So
of the
it
hotel.
was incumbent upon you. You kept quiet. You are claiming equity from us. You must come before us with clean hands.
Milord, I will prove before your lordship that,
You
Milord,
prove in the original application, but first you have to demolish. You restore, your application will be considered. What is the problem?
Milord, kindly have a look at. Milord, I understood your lordship's point. Milord,
Kindly come to page 108. What has
Milord,
been
kindly appreciate, Milord, on only 2 documents, and thereafter, Milord, I will 108. Milord, kindly have a look at, Milord. Page 85, Milord. Kindly take trouble, Milord. Page 85.
now what has happened to the other original application challenging the order refusing conversion? There was any other application?
In my instance, that has been dropped. And I told that, Milord, this is not a case of conversion. This is a case of post-conversion invoking 166.
So you dropped that. So your challenge
It, automatically, the department dropped it. Milord, kindly have a look at the order.
page 108, ADMLRO which is received where it has been intimated to the undersigned that the said conversions cases have been disallowed.
Milord, 88, Milord. Kindly have a look at 88. Milord.
Tribunal application. সেটার কানেকশনে MA অ্যাপ্লিকেশন সেই ট্রাইব্যুনাল অ্যাপ্লিকেশনটা হচ্ছে
199, Milord.
what is the number of that?
MA 199 of 2020.
No. This order of rejecting conversion.
No, rejecting conversion, Milord, kindly have a look at, Milord, page 87, 88.
Conversion.
Milord,
কনভার্টেড সেক্ষেত্রে রেস্টোর করতে বলেছিল, রেস্টোর করেনি বলে এবার পরবর্তী
এবারও অ্যাপ্লিকেশন করেছিল
কষ্টটা তোমার কাছে।
Milord, kindly have a look at page 87 once.
87.
87, Milord. Milord, I may be wrong, Milord, but the fact remains, Milord, I try my level best to, Milord, the appraisal or something.
87.
87, this, Milord, order is being passed on the basis of my comprehensive representation pursuant to the, Milord, the review, passed by the review board.
By the
Whereas it appears that the Gopal Chandra Sarkar, Manik Sardar, both such and such of the Fraserganj, such and such has applied before the BLRO Namkhana for the change of the character of the plot number such and such involving such and such recorded doba for such and such. Whereas it appears that while disposing of the said petition for the conversion, it come to the notice of the undersigned that the subject land has already been converted, being used as a guest house, resort, hotel. Whereas it appears that the said cases does not come under the purview of the 4C1 of the WBLR Act of 1955. Hence, the said conversions case applied in the form number 1A has been rejected, and consequent to the rejection, the proceeding under the Rule 166 of the West Bengal Land Reforms Manual 1991 is hereby drawn up. Whereas it appears that as per the provision laid down in the Rule 166 of the West Bengal Land Reforms Manual of 1991, it requires to ascertain through the inquiry as to whether the change in use has been made in the usual course or by deliberate action on the part of the applicant or the other person. In the latter case, it should also be ascertained whether the change took place before 24th of March 1986. The date of the publication of the
No,
section
kindly
4.
come to the order of 26 December,
No,
final
no,
order.
no, otherwise, this is the premises. Otherwise, that would be meaningless. That's why, I am placing. This should be ascertained from the change took place on 24th of March 1986. The date of the publication of the section 4C of the West Bengal Land Reforms Amendment Act 1981 in the official gazette.
বানিয়েছিল তো ল্যান্ড রিফর্মস অ্যাক্ট এখানে নেই আরেকটা কোথায় Yes, Mr. Dotto, you proceed.
This is very important. Kindly have a look at page 88. The case is taken up for hearing on the 14th of December 2023 and disposal. The applicant remains present, file by Hajira. Heard the case. The applicant mentioned that the change was made 40 years ago, and in support of the claim, the applicant has submitted a Panchayat tax receipt, being receipt number such and such of 24th of March 1980, veracity of which is to be verified by the Panchayat. DA concerned is hereby directed to prepare a letter to the Pradhan of the Fezarganj Gram Panchayat asking him to cause an inquiry and report on the put of the applicant, hereby directed to submit other auxiliary document in support of the claim. Then, my lord, kindly see two documents and thereafter I will place the last portion.
Read the last portion.
No, prior to that, my lord, the document they has been sent. This action has been done. Therefore, my lord, I want to draw your lordship's attention. Page 85, my lord. Then I will place it. Page 85. The concerned DLLR wrote a letter addressed to the Pradhan, veracity of the document being number such and such issued by the Fezarganj Gram Panchayat. With reference to the above, you are hereby informed that during hearing of the application submitted by the such and such rule such and such of the manual, Gopal Sabda such and such has produced the document relating to the Panchayat tax receipt being number such and such issued by the Fezarganj Gram Panchayat, Namkhana Panchayat Samiti such and such. We are requested to go through the and scrutinize and verify the said document carefully and mention whether the said document authentic or not, or whether that has been issued from your good office. You are also requested to furnish supporting document evidence if the said document is found authentic by you. My lord, kindly have a look at page 86. Issued by the Pradhan. First of all, congratulations on behalf of the such and such. A letter sent by the VD memo number dated such and such. In compliance with the instruction of the letter, I assure you that the late such and such father of the such and such personally knew the said person. It is true that the said tax VD number such and such for the collection of the taxes, duties and the fees 24th of March 1980 as per the Gram Panchayat rules, and it is also proved that the Honorable Pradhan on behalf of the Fezarganj Gram Panchayat on 10th of November 1998 recommended for the settlement of the particular land is also true. Photostat copy of those documents are found in our file after the extensive searching. Therefore, sir, there is no difficulty for our side for the authenticity of those two documents on behalf of the said persons, whatever decision finally confirmed and the definite beneficiary. So, my lord, the document which has been issued by the authority, only they would be the repository authority. So far is the, my lord, the section 9.
What are the attached documents?
My lord,
Attached documents to this represented 21st dual
that is both the documents, my lord. That has already not been attached. The same document has been attached. The document
receipt.
Panchayat receipt.
No, the second part on behalf of on 10th of November 98 recommended for settlement is also true. Where is the document to that effect? Photocopies of those two documents are found in our files after extensive searching. Where is that document?
That two document has been already been given, my lord. That has not been annexed. If your lordship, my lord, pleases, I will place it, because that has been placed before the way, and subsequently, my lord, that has not been tagged over here.
Yes, but the DLR also directed you to submit auxiliary documents to support the claim.
My lord, kindly appeal.
In support of your claim, you have already only produced one tax receipt from 1980.
My lord,
Now you come to page 88. The applicant is hereby
Eight-
directed
eight-
to
88.
submit
88
other
right placing.
auxiliary documents to support the claim.
My lord, I am.
We have failed to do so. Now,
No, it is not me, my lord. It is up to the authority to support that document if any ancillary document is there.
applicant is directed to submit other auxiliary documents.
After perusal of the said document, which is the receipt of the such and such taken, such and such is directed to require authenticity of the said document needed in supported by the auxiliary document. My lord, auxiliary document I don't have. Because, my lord, I have to show that in that plot of land, my father had been residing. Apart from this, I don't have the document. So far as the section 90 of the Evidence Act says, if any person produce certain documents, who is the custodian of the documents, the presumption will go in his favor. So may the law of presumption is in my favor. I will, my lord, in reliance thereof, my lord, I intend to produce, my lord, two decisions to that effect of this Honorable Court and the Supreme Court also. So, my lord, the authenticity of the document can be questioned by the authority who is issuing it. Other authority cannot question the authenticity of the document. If he question, in that event, he has to submit certain other documents.
You 26 December 2023 order
My lord,
that was challenged in your OA.
my lord.
Which OA number?
Way number of 61 of 2024. This is, my lord, that has been annexed.
Number
61 of 2024. My lord, page 19. Kindly have a look at page 19. It starts from.
Now, after this order of DM, which you showed us, ADMLR,
My lord,
this was passed on 26 December 2023.
my lord.
That must have been placed before the prescribed authority now.
No.
That
What
26
happened? What happened, my lord? Kindly take a note of it. That, my lord, that subsequently an order has been passed.
Who is the prescribed authorities?
Concerned BLLRO.
PLRO.
BLLRO. BL and LRO.
Very good. Now, where in the order sheet which you have prepared, which you have annexed, where does it mention that 26 December 2023 was placed?
23 has placed, my lord, before the way.
26 December 2023 order was passed rejecting your application under Rule 166
My lord, 20.
by the DM.
My lord.
Now, in the midst thereof, the proceeding was started,
No, my lord, kindly, I am telling you.
page 102.
No.
After the High Court order, the proceeding was started on 16th of first order was passed 8th December
23.
Very good. Now, after 8th December 23, your conversion applications were filed when?
Immediately thereafter, my lord, I have made an application on 6th of December 2023.
Yeah, just. 6th of December.
2023.
Now, where that has been dealt with in the order?
No, that has not been dealt with because
It has been dealt with.
my lord, kindly appreciate towards
Page
the
105. Page 105. Last paragraph. Read the last paragraph.
whereas it appears that
Hmm.
the private respondent number 13 and 14 such and such, the address has been mentioned before the ADM DLL or such and such, which is revealed under that the aforesaid respondent filed two conversion cases, classification Duba Vastu such and such, still the pending of the adjudication of the submitted the same of the document and the claiming that the said Vastu prior to 24th and they also submitted a representation dated such and before the undersigned regularization of the concerned plot, Rule 166 of such and such.
Now, this application was rejected by 26 December 2023.
My lord.
Now, thereafter, what does he observe? Whereas it appears that the private respondent
Respondent number 13
and your
and 14
conversion cases are still pending.
No, they have dropped the conversion proceeding. My lord, I
You
have
allowed it to be dropped because after that your sole prayer was considered the claim under 166.
it is the understanding of the authority.
Forget about that. What is the fact? That was dropped, whether at your instance or at the instance of the authorities, we are not concerned.
Only by
No, we have heard you. You made an application under 166. 166 has been rejected by the competent authority. When it was rejected, 26th of December 2023. High Court order was on 6th. High Court order was on 16th October 23. On the basis of that, the BLRO initiated on 8th December 23.
Only fact.
We listen to you. Let us clear the facts. Now, kindly.
That's why, I intend to place it on record before your lordship, my lord. The fact is these two separate proceedings. One is 4C for the conversion. One is 4C5.
That has been dropped.
That has been dropped. But the 4C5 has already been initiated in the April 2023, which take cognizance by my lord justice, honorable division bench of this court, saying that you complete the proceeding 4C5. This is a penal action.
Yes.
But 4C is the conversion. So 4C proceeding, which is pending since 2008, my lord, I pursued, and that thereafter that has not been taken care of.
No, 4C proceeding was not in 2000. Your 4C.
4C proceedings has been concluded holding that it was an unauthorized conversion.
No.
Then direction was
Not an unauthorized construction. Since it is a case of post facto, my lord, conversion, therefore
when you made application to invoke 166 of the manual,
no, my lord.
declaring
Immediately
post facto approval of the conversion, you try to in pursuance of the
I am not clear to your lordship, my lord. After passing the review order, my lord, I first make a comprehensive application, saying that this is
when the review order was passed.
Review order passed on, my lord, 1st of December 2023.
December on the date.
1st of December 2023.
1st of December
2023.
2023.
Review order has been passed. I made an application
On 18/12/2023, come to page 120.
Will you kindly have a look at thereafter I made an application on 6th of December 2023.
Come here, we have understood. Come to page 102.
102, my lord.
It is a proceedings under
4C5.
4C5.
This is a penal provision. It is not the conversion. This is a penal provision.
Penal 4D. 4C5.
4C5.
It was initiated on the basis of the order passed in public entire litigation.
My lord. No, prior to that, it was initiated on, kindly have a look at, my lord, page 703. Kindly see, my lord, page 71. Page 71.
সেটা পেন্ডিং ছিল বলে হাইকোর্টে এই অর্ডারটা।
Page 71, my lord.
Yes.
This is a memo, kindly see, dated 10th of April 2024 in the memo reference number
71.
Page 71. This is a memo dated 703, dated, my lord, 10th of November.
November 2020.
Yes, referring a memo 209 dated 10th of April 2023 by this office. So, my lord, the 4C5 proceeding has been drawn prior to the institution of the public interest litigation.
Yes.
Yes.
So, subsequently, my lord, since, my lord, that has not been proceeded with, then, my lord, the writ petition has been filed, public interest writ petition has been filed, and an order has been passed. So, I made a review. Original, my lord, the initiation of the 4C5 proceeding.
Yes, 4C5 proceedings
Was initiated by an order dated 10th of April 2023.
On the basis of an inquiry conducted by the concerned revenue officer.
Right.
Whereby you are directed to restore the water body within 15 days.
Right.
Thereafter, the said 4C proceedings was not concluded, and one Indonal Pramanik approached this court by filing a private entire litigation.
Indolor Paramanik, which has not on the record, my lord. Indolor Paramanik, it has been recorded in my representation that he is a primary school teacher claiming to be the Borgadar, mine Borgadar.
In that circumstances, you have to assess that order before the Honorable Supreme Court. That it was not in fact a public interest.
So I am not, I am not on Miller. I am not on Miller. I am on so far as my right is
That
concerned.
cannot be done. Now that public interest litigation was disposed of by directing that you disposed of the fourth report. Now you file a review petition. Then review petition, while disposing of the review petition,
No, no. সে তো হলো,
a liberty was given to you to raise all the points.
Then Miller, on 6th December, I have
Now, while raising all these points by making comprehensive representation, you ask the authority to invoke 166 of
my
the
lord,
manual.
my lord.
Why 166? That there are 4 conditions. By filing application for comprehensive representatives, you showed that, okay, it has been converted. Now give me post facto approval or post facto approval of the conversion. Now in support of such claim, you place one property tax issued by the Panchayat of 1980. The said tax issued was sent to the Panchayat for verification. The Pradhan said yes, it was duly verified and authenticated document. Now DLRO did not accept this because DLRO asks you to submit auxiliary document to support your claim. You have failed to submit the auxiliary document. DLRO disputed the authenticity of the property tax. It sent this for verification and asks you to submit auxiliary document. You have failed to do so. DLRO came to the conclusion that there is no occasion or this case does not fall to invoke 166 of annulment. Now it challenged the session. This
You
is the
restored
position.
it, Mr. Dotto, you restored it.
Miller, kindly have a look at Miller.
Restored.
Miller, demolish, there is no difficulty. Miller,
Yes.
kindly hearing me, Miller. I don't have any case to satisfy your lordship, Miller. But the fact remains, Miller, only the thing is this.
That
Kindly-
the tribunal will consider. Tribunal original application
Miller,
is pending.
in that event, Miller, what would be undone that cannot be done, Miller. Kindly appreciate, Miller.
No, it will, why cannot be done? You have to raise further construction. But we cannot, it
Miller,
is a-
only this, if I satisfy your lordship, Miller, if I satisfy your lordship, that, Miller, the ADMLR, that taking decision, disbelieving the document, he cannot do that. Miller, kindly have a look at, kindly take the section 91 of the evidence
166
fact.
final order, 166 final order. You, 26 December 2023, that is the subject matter of challenge in the pending original application.
My lord,
But in the meantime, you have to restore it. All these points will be gone into restitution.
Miller, suppose, Miller, kindly appreciate.
Tribunal has rejected on that ground.
Miller, kindly appreciate. Miller, kindly appreciate.
Mr.
Miller-
Dotto, your conduct is not good. An equity court will consider your conduct.
Miller, kindly appreciate at the same time.
Pardon, Mr. Dotto.
Miller, kindly appreciate at the same time. Miller, if I, Miller, demolish the structure, if the court hold that the order which has been passed by the ADMLRO bad, how my right would be protected?
Compensation. Get compensation. What is the problem?
So, Miller, only the fact is this. Miller, kindly have a look at only,
You
Miller,
tried your best, Mr. Dotto, but what can be done?
Miller, only kindly appreciate, Miller.
Yes, we are hearing you.
Miller, section 90 says presumption as to the
We
document.
need not. What is under challenge before us? Challenge before us.
This is co-terminus, Miller. This
No,
is
no.
co-terminus.
No, sorry. You can
If I don't satisfy your lordship, Miller, the
Argue.
merit of the matter, your lordship will not consider because
You
this
got
is not of the
enough
challenge.
leverage. You
Court
got
fee-
enough leverage.
And
86, we are in 24. One conversion case filed, thereafter dropped, rejected, 166 invoked. High Court said, the coordinate bench has said, made observations. Sorry, we cannot help you.
And
Miller,
three
Miller,
weeks already
only,
gone. 3 weeks already gone, 15 February.
no, 30th from the Miller, the 3 weeks,
30th February, 30th January. then
30th
next-
January, this order has been passed.
Next week would be 7. Oh,
No, Miller, that would be 21st.
21.
Only Miller, I am beseeching before your lordship, Miller. The ADM DLR doesn't have any authority to disbelieve the sanctity of the document because the issuing authority is saying that this document has been issued by them. Honorable Supreme Court of the Honorable High Court.
You could have got that certificate way back, 86. From 86, you come to the Panchayat in 23 at the instance of the order of ADMLR.
No,
So,
I am
well,
having a tax document, Miller. So I have produced the tax document. They have.
When have you produced, sir? You produced it in the year 2023. Everything was quiet. You're running the business. Why will you unnecessarily dug your own grave? You kept quiet.
Miller, kindly see only one document. Only one document, Miller.
Stand, Mr.
Miller, kindly see single document, Miller. I draw your lordship's attention. The comprehensive representation, page 78. 78, Miller. Apart from the said document, Miller, I have already relied upon the list of documents which has already been mentioned.
Yes. Yes. Page 78.
Page 78, Miller.
Yes.
Miller, I have already placed. Miller, kindly see the page 78.
Yes.
This is my representation, Miller.
Yes.
In the said representation, Miller, I have categorically stated the other document which has already been relied by me.
That is the tax document.
No, that is apart from the tax document. Kindly see page 79. On March 8, 2023, the two applications that has been initiated when? Miller, April. On March 8, 2023, two application being application number.
Where you are reading page 79.
Last paragraph, Miller. On March 8, 2023, two application being application number.
Your conversion case.
Prior to initiation of the proceeding.
That is at your own seeking. You wanted 166. That you apply 166.
So, my conduct is this: prior to initiation of the proceeding, I have started a proceeding, Miller.
When that was in December 2023.
No, kindly appreciate, Miller.
When from your father was having the Panchayat document?
Since prior to 1980.
Very good. From 86 till 2023, you have done nothing, Mr. Dotto.
Miller, prior to
hand in gloves with the state respondents.
Miller, kindly appreciate, Miller, the authorities. Miller, kindly appreciate, Miller. Kindly appreciate. Miller, I'm showing my conduct. Since, Miller, it was fallen from your lordship, Miller, I'm showing my conduct that apart from this document, I have approached since 2015 also. Made a conversion application that has not been considered, that has been kept pending. Subsequently, we moved the LRTT. The LRTT, Miller, the matter has not been taken because, Miller, they are the ignorant persons, Miller, and they are the, Miller, the poor villagers. Miller, kindly have a look at, Miller, kindly allow me to.
Yes, Mr. Dotto, we have heard you.
Miller, only I intend to cite few decisions to that effect, Miller. Miller, I want to few decisions. Miller, I intend to. Miller, I intend to place few decisions, Miller.
We have heard you.
No, Miller, I intend to place certain decisions, Miller. Otherwise, Miller, Miller, great.
30 years old document. 30 years old document.
30 years.
Miller.
Okay, this.
Please, bolo dao judgment. Yes, give the judgments.
Miller, this is reported in 2018 SCC Online, Calcutta. One 15362, my lord.
2018 SCC online 15.
15362, paragraph 30. Division bench of this honorable court. My lord, a certificate has been challenged on the issue. Paragraph 30, my lord. It was entirely upon the institute issuing the decree to Dr. Utpal Sharma to have challenged the decree, late annual challenge. All the concerned institute repeatedly corroborated and reaffirmed the genuineness of the details furnished by Dr. Sharma for being appointed as a principal. Despite such document being on record, those were discarded and overlooked and the glossed over merely because those were not contemporaneous with the issuance of the certificate under consideration. In the circumstances, that totally irrelevant yardstick. Miller,
Yes, Mr. Lord.
Miller, this is a decision reported in 2021 to SCC 718.
Para?
Paragraph 13 and 14, Miller. Paragraph 13, Miller. 8th line from top. Paragraph 13.
Paragraph 13.
8th line from top. The attempt to procure certified copies from the municipality was also unsuccessful as they were informed that the original files were not traceable. The photocopies were marked as exhibit without objection. The respondent never questioned the genuineness of the same, despite the aforesaid fact that those documents were more than the 30 years old, were produced from the proper custody of the appellant, along with an explanation of the non-production of the original. They were rejected without any valid reason, holding that there could not no presumption that the document executed by the public authority had been issued in proper exercise of the statutory power. This finding, in our opinion, is clearly perverse in view of the section 114 illustration E of the Evidence Act of 1872, which provide that there shall be a presumption that the all official act has regularly been performed. The onus lies on the person who disputes the same to prove otherwise.
Yes.
Sustainability of the order dated 19th December, February 2024 has been called in question in this petition. Has been called. The order dated has been called in question. Issues of the selection has been softly the fact of the fact before the stupid the physical activities of cities of the both the petitioners inherited the subject of upon the observance of in the report of rights, the subject of loss of land was recorded as but on an inquiry conducted by the concerned, it was found that the said plot of land converted to a particular land And accordingly, the proceedings under Section 4C5 of the West Bengal Land Reform Act 1965, Faculty of the Act of was initiated by the Block Land and Land Reform Officer. There is tendency of that possible one public interest was left before first paper, before this which was disposed of coordinate range of this is disposed, which was disposed of by an order by coordinate by a coordinate range of disposed by an order 16th of 2002 by directing the concern the state of the foresee within the outcome of 55 and with the purpose direction that we found that the land was illegally constituted. The person was responsible for such illegal. The persons have been directed to restore blessing is obligation. In accordance with the state order, the proceedings initiated under 4C5 was disposed of by directing the petitioner's hearing to restore the land is page 110. It's obligation. By an order dated 2024 within 2 weeks from the in the latest plan, the petitioners prepared an application for the application report and the series of the order passed in the public
Order dated 16th October 2020,
October 2023.
page 66, and the same was
And
disposed of
the same was disposed
by an order dated
by
1st
an order dated
December
1st December 2023, holding that there was no error happening on the system and there was no count to exercise the however, it was observed that it would be open to the applicant seeking review of the order to raise all the issues before the concerned topic in pursuance to the proceedings initiated under the West Bengal Act 19. The petition
pursuant thereto,
pursuant thereto, the petitioner filed a comprehensive representation before the prescribed
on 6th of December, page 78.
before the
Competent authority
competent authority intermediate on the ground that from the stat receipt issued by the Consult Panchayat Panchayat in 1980
86.
and 80, it is that before the West Bengal amendment came into force in that receipt, the land was contracted pasture, and hence fear was made to invoke the Manual 166 of West Bengal,
Rule 1.
Rule 166 of West Bengal, Land Reforms Manual, for obtaining post facto approval of the tax receipt was sent to the Panchayat Office and the applicant was also asked to submit the auxiliary document to support their views. So, ultimately, by passing an order dated 26th December 2022, the DL and Pillar of concern
Page 187. ADM alert to 166 এর copy.
stated that said that by all around all the offices of the state of the disputed the authenticity of
At the point,
observing that the authenticity of the receipt cannot be sustained
cannot
Milord, the,
cannot be
Milord,
as it is
it was not supported by a project either explicitly or explicitly. Or
may I interject? Milord, in my submission, I have categorically stated the Panchayat had
let him complete the order. Any addition you want?
challenging the state order passed by the DL and Pillar son. Justification of the original application number 2024. And since the since a direction was given upon the competent authority to post the structure standing on the subject plot of land will be approved from the date of passing the order at 1st January 2024, the petitioner preferred and miscellaneous application seeking interim order of stay of the order dated 30th January 2024, and here for issuance of the order of stay of operation of the order dated 30th January 2024, and hence this instance petition Mr. Dr. Lamet, advocate appeal for the petition. Please. That the past the authenticity of the receipt stands admitted of the memo dated 21st
December 2020.
21st December 2020. He submitted that that receipt is a 30 years old document, and hence in terms of the provisions of section 90 of Evidence Act 1872, Because the authority concerned was required to presume that the said document
Then,
and
in support of such contention, he has placed
in
reliance
support of contention, he placed reliance
upon the judgment
upon the judgment
delivered in এই দুটো। একটা হচ্ছে 2021 SCC আর একটা 2018 SCC।
He submit that the official is going to stand on the subject of intervention of this court is very much required and appropriate interim order is very much required. Appropriate interim order is required to be passed to restore the authority. Concerned to interim orders.
As the government
As the petitioner by by making the comprehensive representation as made out to the article and if such interim order is not granted, the petitioner shall suffer
irreparable.
So, Mr. Tapabrata most
State.
all such contention of the
Scrutinize and excuse the contention of Mr. Dr. Petitioner has used the OPP and accordingly, and as such, the interim order was rightly refused by the arbitration clause. But
that's all people of
and not only
order. Yes, that the order has been passed in compliance with the order passed by the bench of this court which are and the petitioner has not denied that there was no action of the other petitioner by filing the comprehensive representation in terms of the order passed on application of the order 16th October 2003. It made it clear before the action of the court. 166 of the that DL and Ricardo has passing an order as contract that it is not a it is the and since the order that was passed in compliance in terms of the past plan,
the coordinate
coordination and since observing this and that to include as short forward and be of this should be detailed therefore the judgment relied on what we see the distribution the judgment relied upon by
Mr.
Dr. regarding the becomes content in section is distinguishable
and cannot be applied under circumstances of
Miller, one aspect, Miller. Miller, kindly see the order impugned where it has been stated that, Miller, the point of maintainability would be kept open. They are, Miller, the dismissing my, Miller, the MA application, disposing of the MA application. And in the other hand, they are telling that
in the original application.
Miller, original application is the offshoot of MA application, Miller. Suppose, Miller, a writ petition, a can has been disposed of.
MA is the offshoot of original.
MA is the
MA
offshoot.
is not the offshoot.
Correct.
Question of maintainability of the original is pending.
Yes.
The MA application is arising out of a way application. Since, Miller, MA is being disposed of, therefore, Miller, it would be presumed that the existence of the way application has been, Miller.
That you can deal with in the tribunal.
That
will be there in the tribunal. This order is not pertaining to that issue.
No,
Yes.
this order is under challenge before your lordship, Miller. The order,
Yes.
order dated, Miller, 19th of February 2024
We
is under
have-
challenge
we have
before your
not
lord. This is
injured
completely
the-
contradictory
Why? Why contradictory?
because, Miller, kindly have a look at
As
the penultimate paragraph.
yes.
Let the matter appear in the list of hearing on the point of maintainability on the 4th of March
Yes,
2024.
that is your original application.
This is,
What will appear on 4th March? Your miscellaneous application has
but
been
miscellaneous
dismissed.
application can be taken up if the original application would be maintainable. If Miller, the original application is not maintainable,
No,
I would not be permitted to
This observation is in view of the original
My-
application, not the miscellaneous.
Great.
Yes, next. নামটা yes next
এটা আসছেন আমার ছবিটা আসছেন May it please your lordship,
yes Mr.
I beg to appear virtually, my lord, on behalf of the appellant.
Who is your side?
Lord, Mr. Siddiqui was here, Lord.
Where is your other side?
He was here just now, he has left.
Where is your service?
Lord, I have some. Even, Lord, yesterday also I intimated them that the matter will be taken up tomorrow.
Yes, where is Mr.
Yes, he is also.
No, I'm not there in the matter. That is the difficulty. Mr. Supratim thought and only Mr. Siddiqui is engaged in another court. He was
You should have told Mr. Mukherjee earlier. He was online sitting online.
but
No, it's all right. It is all right, my lord.
I was not aware of this. I tendered apology to this court and Mr. Mukherjee. I was not aware
No,
of
no, it's all right. No, all right.
Can we take
Hello,
it?
time.
You have matters on 2nd, na?
I have matter, my lord, on 27th. Kindly put you on some other date.
All right, then it will be on 5th of March.
Lord, today is the hearing before the revenue officer. Lord, he will, Lord, correct the record of right and take the land into the collector's courtyard. Lord, that is why we have come, Lord.
What interim order you want?
Yes, I have.
Status quo.
May I request Mr. to take up this at 2 p.m. subject to Malot's convenience.
So 2 p.m. we have fixed another bench
Oh.
we have. Oh. All right, come on Monday. Come on Monday. Yes, next.
Okay, Bolaji.
For the response.
Yes, yes. Item number
6.
6.
My lord, a difference in opinion, my lord, between the two members of the learned Central Administrative Tribunal. The matter, my lord, is relegated, my lord, to the third member, honorable third member. The third member, my lord, holds as against me.
Third member holds.
My lord, as against, my lord, this applicant. And my lord, therefore, the original application is dismissed. Now, my lord, if your lordship, my lord, kindly comes, my lord, to the
This is on compassionate appointment.
compassionate appointment.
So it has to be heard, Mr. Das.
Lordship.
Pleadings have been exchanged in
But
the,
before the tribunal, reply rejoinder was exchanged.
who is your other side?
Mr. Gupta.
Yes, Mr. Gupta.
I
You
am,
file opposition.
my lord, firstly, this application is not maintainable
Acha,
after
will you
19 years.
file affidavit or not? Or if you do
I
not
shall
file,
file.
we take it up.
I shall file.
Asho, the present writ petition has been preferred, challenging the order dated 14th October 2022, 17th October,
17th October.
asking the original application with OA number 350. Heard Mr. Das, learned advocate, appearing for the petitioner. Stop. Mr. Gupta, learned advocate, appearing for the respondents. Prays for leave to file an affidavit in opposition to the said application. Stop. Let such affidavit in opposition be filed within 3 weeks.
My lord, yes.
Reply thereto, if any, be filed within 2 weeks thereafter. Stop. The parties would be at liberty to mention the matter for final hearing after the expiry of the period as fixed above towards exchange of affidavit. Chopore affidavit of service as filed. It is compassionate appointment.
Lordship, compassionate appointment.
Why? What? Under the
Well,
railways.
And under the railways,
What's the difference? One member allowed.
one member allowed, directed for reconsideration. The other member said, no, since I have submitted a fake certificate, the railway circular should, according to the railway circular, I am not entitled. The third member, my lord, holds the view of the second member.
After 19 years.
Because there is a circular of the
But there is a
that
circular, my lord,
applications
but my
can
lord,
be
kindly
taken.
sees one thing,
All
my
right,
lord,
we will-
lordship.
Yes, next.
But only one thing, my lord, the school which had issued the certificate,
Hmm.
but I have made the headmaster of that school as a party
Hmm.
because he was a party before the tribunal. Well, let the headmaster file an affidavit because my lord, he is the person who can my lord, clarify the situation.
Already
Opore
fake.
affidavit of service this. Stop. No one appears on behalf,
Respondent number 4, my lord, we have served
one
it.
appears on behalf of the respondent number 4. Stop. Hard এত such and such. তারপর Mr. Gupta press ওটা the parties এরম দিকে দাও. The parties are directed to file their affidavits in opposition within such and such reply thereto.
Grateful.
Yes, next. Seven. Yes, who is there?
My lord, item number 7 and 8, I am praying for not this week on behalf of D.N. Roy, appearing for the petitioner, my lord.
2 weeks করে দাও. Yes, 7, 8. Next.
Lordship, I appear for the petitioner. The service is still not complete. Kindly take it up after 2 weeks,
2 weeks.
as we might have to effect hand service. As we might have to effect hand service.
Yes, 10.
My lord, Mr. Ujjal Rai is appearing on behalf of the petitioner.
2 weeks. Yes. 11.
But 11, my lord, I'm led by Mr. Motisaga Tiroi, my lord. I'm praying for a week's time, my lord. He's
Why
unwell.
do you file,
I
sir?
My lord,
appear for the
2
respondent.
weeks. Yes, next.
grateful, my lord.
Well, I'm for the petitioner. I'm for the petitioner. I'm praying for 1 week time.
You mentioned this was filed without certified copy. It was so urgent, and now your
My
counsel.
senior is out of station.
Why did you seek leave to file without certified copy? Is this
My lord, I have to take instruction. I don't know anything about this matter. I was not present at that time, but I don't know anything.
Yes, sir.
And he is ill also. He is suffering from severe infections.
2 weeks.
Okay, okay.
Yes.
Grateful.
File the book. Yeah.
Right side.
Yes, next.
I'm sorry, Lordship, regarding item number 8, perhaps.
Don't mention. Yes, next.
Sorry.
Yes, sir. 2 weeks.
My lord, and for the petition, my lord, it was a restoration application, my lord. Of the last occasion, my lord, it was dismissed for it.
Have you served?
Yes, my lord. This is what.
That is the way of service.
My lord,
You are required to file an affidavit of service. দেখি কি where is your affidavit of service?
my lord, that is not my I will prepare now.
Who are the respondents? Service is not complete. That is fix করে একটা হেড করে দিই কমপ্লিট সার্ভিস yes next item 15 restoration
This was a restoration and
service complete
service has been complete. This was listed, what you directed for a service, and we are here. Okay. Service to
what is the main matter about
Main matter with regard to a compassionate appointment.
compassionate appointment
Yes. Main matter.
you never appeared
No, no.
First
We appear.
8th of June
We appear. What is happening
8th
after
of
this particular bench is available with a single judge over there?
Hmm.
Regularly, persons went, and as per when it touches the hearing zone, it is rescheduled to a next day. This is the difficulty.
what we didn't follow
Whenever it touches the hearing section,
Huh.
it is rescheduled and relegated to a next day. Never the hearings are being taken up. This is the difficulty. Now,
You
Lordship,
did not appear how can you take that stand
we appeared prior to that. I know that I personally annexed those.
so when did you appear
Yes, Lordship, have a look.
matter
will-
was thrice taken up
Yes, Lordship will find from
8th
here.
of June
Lordship will find 43, Lordship take that.
page
Lordship,
43
Page 43
of the
of the main application. That is
What is-
91 of 2023.
43 is before tribunal
Yes.
we are asking before this court
Before this court, only once this matter.
no no
Yes.
8th of June you did not appear 12th of June you did not appear next it appeared on 25th 12th of June it was dismissed
Yes.
so what is the
On the
wrong
very next day it was dismissed. It was even not served on that particular day. Thereafter, I felt this restoration is being listed here before this.
what was not so
Only once it appeared.
what is your reason what is your reason you did not appear
It was ill. Paragraph 2.
দেখি এমডিও সার্ভিসটা দেখো
Appear service this year.
Hello. When did your predecessor expire? Compassionate
On the
appointment?
main. This was in 1991.
Which order you have challenged? In the main writ petition,
Yes.
you challenged 5th of March order.
To be honest, what we are on at this present juncture, the matter is not being taken up before the tribunal on regular occasions. That what was indicating on the 31st.
You are challenging order.
Lordship may take it up 5th.
5th of
5th,
March.
yes.
So that matter was directed to be listed on 30th.
Yes,
July.
thereafter this is being going.
What happened?
Whenever
you filed this application on May 2023.
2020.
So what happened from 21 to 23?
23, if sometimes matter gets out of list and some.
Where have you stated that? Where are the orders?
I've already annexed all the orders, Lordship. You will find from page 43 itself. 43, 42.
So when is the next date fixed?
It is out of list at this present moment, and the difficulty is what is
out of list?
Matters before the tribunal. The hearing is concerned. It is
Don't
not.
make that submission, Mr. This is a common submission made in High Court by.
Lordship need not to believe me. Lordship knows.
You have assailed
In
the order
fact,
5th of March 2021. We are wanting to know what happened on 30th July 21. And what happened from 21
subsequent
to
thereafter.
20. Yes. What is the use of keeping this application pending? You tell us the returnable date, we will dispose it of requesting the tribunal to hear the main matter.
Lordship, only one request. Delegating the matter once again before there won't help me. I have an order with me from my Lord Justice Tandon with this issue.
With this type of conduct on your part.
With a better conduct on my part, to be honest.
Show us what you have written from 21 to what happened on.
Let me get back with orders. Lordship, since your Lordship is of the view, what happened after that, let me get back with the orders.
Which order?
After 21, what happened?
Yes, come with that.
With a supplementary, that would be better.
No.
With only with orders.
You come with the order and your statement, we will dispose of it.
Great. Well, Lordship, only one thing, Lordship need to restore it first. Lordship need to
We will restore
it
and dispose of the matter.
Lordship can restore it now. So
no, it will again go in the folder. You come and tell us.
Then Lordship is posting it on. Only one prayer. Lordship, kindly don't relegate there to be heard out. But because I have faced that music, I can place the order. I went before the tribunal. He says this court may direct me. I can't because I am handcuffed at this present moment with a single member.
Don't make so many submissions when your application is challenging an order of 2021. Matter was fixed in July 2020.
This is
no. This will not happen. You have to justify your case. It is not a post office that you are coming. That I have dropped the letter, you send it there.
No. These fixing and refixing are.
You show us from 21st July.
What happened?
What happened?
Great.
Well, in this matter, I am very for the state. I am led by Mr. Tapan Kumar Mukherjee. Kindly look into this order, my lord. Yes, my lord. That order was not annexed herein. It was out of list, my lord.
Yes, I pressed. On the very first submission, it pressed it out of list. Unless they're traveling there, won't help.
Have you seen
that in the past 4 occasions none had appeared on behalf of the applicant?
I know what's why. I put a question to myself. Why?
Writ application,
I
my lord.
told before
When
the
is the
court.
next date fixed?
Yes.
And the liberty to mention.
Liberty to mention.
Yes, my lord. Let the matter go out of list, liberty to mention. It was on 2nd September 2022
Conduct is not proper, Mr. Banerjee. You do not have the copies of the order.
No, that I told at the very outset. It was.
What will be your justification that you have not appeared 4 times?
Yes.
What will be your justification?
To be honest, I should be. If your lordship allows me to speak aloud, I can. The difficulty is
The honesty. What is the
traveling over from here to there and get an order of adjournment. Is it at all helpful for everybody?
That is the procedure every advocate follows. You are an exception.
No, I would not. No question of
Your
exception.
advocate on record is an anyway. We will not go into. You show us that order, we will pass necessary. What you want
Lordship
to
has
argue?
already found.
Huh?
Lordship has already seen.
Yes, then argue. What is your argument?
And I don't know another thing, my lord. The restoration application has not yet been served upon us.
No, I've said.
No, upon us.
The difficulty is whenever we went to serve on the government leader's office, they said to you serve on the person concerned. I approach with my this appearance before the court. Lordship asked me to serve on the respondent concerned. I've served. Now they are without the restoration application.
Which you wanted to serve upon the GP. Where is that letter?
Petition itself.
A petition was served, but not the restoration application.
Restoration, I intended.
Without any covering letter. You went to the circuit.
I went to further service. Why I should unnecessarily getting an order for a service?
Yes,
If
where
which is
is that service? Come to your affidavit of service.
yes, I've already served.
What you have served?
I've given the affidavit service. There was a direction Lordship will find from your Lordship's own order.
Your affidavit of service, where you have served the restoration application. Mr. Banerjee, this is unfortunate. You are not a toddler. You should not go through this. Whatever your advocate on record will say, you will serve.
Not only that,
Read paragraph 2 of your affidavit of service. Come to your letter of 29 January. Where have you said that you have given the restoration application?
This is subsequent. Lordship, kindly have a look. Lordship's own order, which was passed.
Yes.
Yes. Lordship, kindly have a look. This was the direction from the court.
25th January, we passed the order.
Yes. Therefore,
Send it on 29 January.
29.
Where is the application you have annexed? Huh?
With the application.
Yes.
Lordship, kindly have a look at my this covering letters along with the postal annexures.
Yes. Read your covering.
Yes. Lordship will find the same from fourth, page 4. Page 4.
Where is the statement in your letter that you are enclosing a restoration application? This is High Court.
লেটারটাই বলছি সেখানে কোনো ইনক্লুড সেটা বলছি
No, I have annexed with the.
Then you will argue. You will again argue, saying that though I have not written it there.
No, can is there, number is there.
Oh, the number is there, application not required. You will still argue. Where is the restoration application you have served? You are blaming him?
No, I am not blaming him.
Now you said.
We went to serve on the government leader's office. I am not mentioning any person's name.
This letter, where does it show that your restoration application you have sent?
The payment.
Read the letter. Now today we have to read the letter along with you. Your conduct is not proper, Mr. Banerjee.
Lordship is getting stricter.
Do you support this conduct?
No, this is absolutely bad. But the payment we have given, that could not be without the application. This is what I intend to mean.
So the court has to assume that you went to the.
No, the court need not to issue. Once I am before the court, at least.
We have asked you a question, answered the question. Have you written that restoration application?
Wrong. I'm stating wrong.
But show us what is in the merit of the matter. We will discuss. Give a copy of restoration, please. You will not be able to argue because you have not stated anything. Your advocate on record has stated nothing.
His lordship is taking up the restoration application.
I'm taking up the main matter.
Main matter.
Please go through the brief before you appear. Because when you appear, when an advocate appears, court has a prima facie belief on the advocate.
No, true. That's why I thought it's wrong.
এটাকে to be mentioned লিখে দাও তো। Give a copy to him.
That's my lord. Sir.
এটাকে to be mentioned লিখে দাও। 6 তারিখ 6th March লিখে দাও to be mentioned. Come with all the orders.
May I take back the instruction, my lord?
হ্যাঁ, ওনাকে ওর order. Yes, next.
Sorry, my lord. Kindly don't take me amiss.
We are not taking amiss the advocates. The thing is the level of advocacy. See, one coordinate bench, you do not appear, matter dismissed for you. It is not a matter of course, Mr. Van. You have to draft a petition, you have to make the fact, then only you can argue. Otherwise, people will be embarrassed. Will it not be embarrassing? Say, moreover, when it is not your fault, it is your advocate on record who did not bother.
You know, when I appear, I take the onus on myself.
Yes. Next.
I can't shift my blame.
6 January, 6 March.
6 March.
To be, it will appear as to be mentioned, you come.
Great.
I wait for the state.
Yes.
Lord, in the last occasion, your lordship was pleased to grant me leave to file supplementary affidavit, my lord. I have served a copy upon my learned friend. This is a matter where, my lord, for about 100 years the petitioners are living by making construction, but the classification is canal. So your lordship was of the opinion, and since on the basis of the report submitted by the state government, that since it's a canal, so record of right cannot be corrected. So this is the background. So I submitted that, my lord, classification was prepared during British, and that needs to be corrected. Why? That's why, my lord, I have prepared the supplementary affidavit. And in the previous occasion, page 19, my lord, if you
was the order impugned?
That is the last page, my lord. That is the certified copy. So, my lord, it's a classic case of facts and fiction.
You preferred an application for correction of the record of rights as riots. And at the
But
same
why,
time,
if necessary, my lord, it can be as a Dokolika, which they also serve my purpose.
the tribunal has rejected because your claim was contradicted.
Yes, earlier the claim was for long-term settlement. The other brother made that application, and this time for correction of record of. Because you are
Brothers
not-
made different applications.
Yes, in 2014, my lord, one brother, that is petitioner number 2, made an application for long-term settlement. On the basis of that, my lord,
Petitioner number 2.
petitioner number 2.
On
Your
the
lord, basis of that, my lord, the PLR prepared a report that is at page 19, my lord. If your lordship kindly
But
come.
that is in respect of Sadhon Chandra Das. Oh,
2 brothers. This time the other brother has come, that is petitioner number 1.
no, Sadhon went first, na? Page 19.
Yes.
Subject is report in
Yes,
respect of Sadhon.
I'm
So
sorry.
Sadhon preferred an application for what?
For long-term settlement.
Sadhon preferred an application for long-term settlement. In that, this report was filed. And what did Rampada do?
Rampada subsequently made another application, that is at page, my lord, 21. page 21. This time the application was made for correction of record of that.
This was made on
Subsequent application was made on
10th of April
10th of April.
2017. Now thereafter you approached, this was not considered. So you filed an app. So you are having contradictory claims.
That is true, my lord. That I cannot.
Then how
deny.
can we help you?
My lord, your lordship is considering the factual aspect and the after the long user of the land, my lord, for 100 years. And the page 19, the deed and BLRO has admitted that we are in possession over the land.
To take appropriate steps on the basis of that observation.
Then,
How
my lord,
can we direct your name to be recorded?
not recorded matter, classification should be changed. That is my respectful submission.
It is a khal.
That is the classification says, but the factual position says otherwise. That series of photographs I have. Annexed,
No,
my
no,
lord.
that is not for us to determine. It is
My lord,
recorded as khal.
Then, my lord, your lordship kindly give me liberty so that I can make appropriate application before BLRO and BLRO to consider that.
So that has not been stopped. Court has not stopped.
Not one, otherwise they will not. Only one line. If the petitioner makes any application for correction of
Which petitioner will make? Your one brother says I am riot. One
My lord,
brother
that
says
was
that I am.
my lord, that was the earlier mistake. They are the village people.
So you don't move the application. Go and
My lord,
file
that
an
was your lordship's suggestion on the last occasion also, my lord. May I just indicate one issue? Actually, what has happened? This has been recorded as water body. Therefore, whenever they approaches, right now, lordship knows, my lord, the situation regarding the water body. We cannot improve the situation. Yes, it is also a fact what we have stated that they are for long staying with a suppose that
Nobody is
two floors.
disturbing
Yes,
you, mister.
nobody. That was
Why
the
you want to dig your own grave?
because we cannot give that permission right now. This is a water body.
Yes, yes. Now it
That is the
comes
difficulty.
That is
And
why we asked you that why don't you? You said I will take instruction and come. If we deal, it will go against you, Mr. Bond. Will it
My
not?
lord, for the sake of the petitioners, whatever your lordship will think fit, kindly pass that. But actually, the long position, my lord, the village panchayat has
That is why we are saying, suppose we dismiss your application. If we make an observation supporting the order
No,
of the tribunal, then that will be more
ruin everybody, not only the petitioners, other people also.
তাহলে কি করবো তবে? Don't proceed then on the prayer of the learned advocate appearing for the petitioners, the original application such and such is dismissed as not present. উপরে দিয়ে দিও let the supplementary affidavit, as filed, be kept on record. ঠিক আছে? ওটা নিচেই দিয়ে দিও। Yes, next. Mr. Ganguly, in item number 3, 4, 5, all government was served, but nobody is appearing. In one matter, Mr. Dhar, you are there.
But in three, perhaps, as I am told, Mr. Galib was appearing.
তাহলে 3 নম্বরটাই ছিল।
4, 5, my lord, I was there, my lord. I was on my legs, my lord. I
Yes,
could not
next
come.
item.
Please, my lords. In the matter, my lord, I am led by Mr. Shokinath Mukherjee. The only difficulty, my lord, I've been instructed is not keeping at all well, my lord.
Yes, he was there online.
He's in a position to talk for a minute or two and then the coughing bout starts. I'm only beseeching your lordships, I've indicated it to my learned senior friend. If it can be fixed next week, my learned friend has a difficulty on next Tuesday because next Tuesday, another matter where Mr. Mukherjee is leading us has been fixed by your lordships on the next Tuesday. But since my learned senior friend has some difficulty, may I beseech your lordships to keep it the week thereafter, any date that suits your lordships.
We passed any order earlier.
My lord, there was no order passed, my lord, in this.
তাহলে ওই দিন রেখে দেবে তাহলে অর্ডারটার পাশে। সেকেন্ড কবে রেখেছি? 2nd February we kept it. না Other matter.
The next Tuesday, my lord, that's 27th, my lord.
I have some difficulty.
Then it will be on 5th
Following
March.
week.
5th March, my lord. 5th March, lordship.
Yes, next.
I'm very deeply obliged, my lord.
The matter I am for the petitioner. This is for lease. This is for long-term lease of the part vested pond where the petitioner are the owners of more than 50% of the said pond. Process was started since 2010 and still not, and the last order.
Yes, Mr. Dhar, what happened?
Till now, my lord, that kindly excuse me, my lord, I have one copy, my lord.
Yes, any development?
Yes, my lord, the last report. Yes, my lord, partly vested, partly Rayati, and the Rayati is now seeking for the lease in respect of the part vested land.
More than 50% is right.
And he is entitled. He is entitled. That recommendation has gone up to the higher authority. Yes,
But
and this is the last report. Now it's pending for consideration before the authority. Keep this matter pending, my lord, for the writ petitioner's sake, my lord. In the meantime, let me try to solve the issue. And that report is in his favor.
Then we send it out of list. You mentioned before us.
Yes.
And we will enlist and dispose of.
No, my lord, kindly do not do that. My lord, otherwise, I won't be able to pressurize the authority. Man.
ওইটা কি ওই 12th March রেখে দিও। এই কপিটা ওনাকে দিয়ে দেবো।
নাহলে আমার পক্ষে difficult.
No.
No.
Come to page 27, which order you have challenged?
My lord, initially, my lord, they went before the tribunal seeking for long-term lease in respect of that. That is at page 18. Thereafter, since they went before the tribunal for non-compliance of the order passed at page 18, they thereafter they filed another way for the implementation of the previous order. That is at page 20. And then, my lord, kindly come to the last order, which is the MA was filed by them. That is the violation of the order passed. Yes.
Yes.
Disposed of application you have passed. Disposed of matter you have filed an application.
As the London tribunal make the observation, the all and everything is in favor of the petitioner and pending before the minister.
Filed another original application to enforce the
Two original application has been filed. Thereafter, MA. Petitioner is moving since 2010. And though all concerned recommended in his favor. I submitted before the tribunal. The tribunal says we cannot direct the minister in charge.
He alleges that contempt petition has not properly been disposed of because still there is something to be done.
Considered.
Yes, next.
12 March.
19, my lord, I am for the petition.
I 19, yes.
I am for the petition.
Supplementary file.
Yes, my lord. I have copy.
Yes, tell us.
Only limitation ground, my lord.
Uh-huh.
Only limitation ground, the matter was dismissed.
Limitation ground. Place the order. Where is the oh
5/9/2023.
limitation on affidavits? It was decided. Huh?
Yes, my lord. Kindly see 5/9/2023.
Page?
In order. Last page, if you lord.
Last. Five nine, which is
106 page, 106 it starts.
Order delivered, my lord. Judgment delivered 5/9/2023.
5/9.
The AMA number such and such is taken up today, which is application under section 5 of the Limitation Act for condonation of delay in filing the present application.
Now, this was after calling for affidavits. This judgment.
No, if your lordship kindly.
Merits. No.
So,
No,
Mr. Ganguly, do you
Affidavit in
want-
opposition was filed by
only MA application.
in the MA application. The main application could not be because delay application that has been objected
So, MA application was on affidavits.
on affidavits.
Yes, please.
Only grounds, my lord, if your lordship, that the counsel of the applicant submits that the impugn order was passed by the appellate authority on 8/8/2019, challenging the present application be filed on such and such. That the said appeal number such was disposed by passing the order dated such and such. Dealing clerk of the learned counsel for the appellant applied for certified copy initially, but the same has not.
So, you are challenging the appellate order of 8th of August 2019 before the tribunal. And you filed the application when?
Filed, my lord, 25 got. Thereafter, my lord, second application filed, my lord, 2012/2019, and
you
got
read
the
then
order.
You read. Try to-
27, my lord. That the appellant applied for the certificate of the instantly, but the same was not supplied on the ground that the order was not signed by the appellate authority.
December.
20th December. That the order of the appellate authority was handed over to the applicant on 7/2/2020. Therefore, the learned counsel of the applicant in MA further submits that the present application was filed challenging the order of the appellate authority on 8/2/2020 by sections of MA. But as per records, it appears that the application was filed not on 28/2/2020, but 27/2/2020. That is not.
No, where you are-
Accordingly, the delay
28
was.
No. Therefore, learned can further say present a file challenging. When was the first application for certified copy?
When the order was passed, but my lord.
On 8th of August 2019.
But my lord, the said slip was misplaced. Thereafter, again file an application.
No, when was that application made?
On the next date, my lord, that the order was passed.
That you have not stated in your petition?
That's my lord. That is my fault, my lord.
In the original application,
Original
you did not
application.
say so.
No, only stated, my lord, that the said application was not. Also stated, my lord, the said application was not misplaced.
File challenging, you know.
Thereafter, file an application on, my lord, on 2012.
Which is this order of 28th February 2020. Read the therefore learned counsel for the applicant in MA submits. Read that the present application was filed challenging the appellate authority order on 28th February 2020. But as per records, it appears that the said application was filed not on 28th February, but on 27th February. What does it mean? We do not. Huh?
27/28. Here is written, my lord, 28th February, and it was 27.
Core application, second application.
Second application 2012-19. Second application, my lord, 2012-19. Made and applied. Thereafter got, my lord, 27/12/20.
27/12, what did you
No,
say?
7/2/2020.
You got the certified copy.
Certified copy. Thereafter, I filed an application 27/2/20.
Thereafter, Council in MA submits present file challenging order of
27/2/2020.
28th February 2020.
File not.
What is the order date of the appellate authority?
Appellate authority order dated, my lord,
Is 8th of August
8th August 2019.
এটা কি বলছে?
Challenging 8th of August 2019 order challenged before this learned tribunal, my lord, on 27th of February 2020. They are saying that on the basis of the application on which this order has been supplied, the order indicates that it has been applied only on December 2019. But they are saying that the first application was made, which they have lost. But there has not been existence of any first application. That is the issue.
No, 8th of August 2019 was the order passed.
Order date.
They have not disclosed the date of the first application.
That is nowhere in the records, nothing, but they are saying that has been made. My lord,
Now the next application was filed on 20th of December 2019.
2019.
20th December 2019. That is more than 1 year thereafter.
Yes, and thereafter, my lord, ready for delivery on 7th of
Not 1
February
year.
2020.
7th of
August 19, order passed. And December 20, 2019, my lord, filed an application.
You filed an application on December 2019.
Yes.
2019, on the same year,
19,
on December
only 19.
So very good. When did you get the order? 7th February?
7th February.
Then when did you
Filed away.
27.
On 27th, filed the
27 file.
this appeal.
27th February he filed.
Filed. Therefore, it has been found that there is a delay of 197 days.
And it will be, my lord, 143 days.
Right.
Because 60
wait,
days.
wait. Applied. What? Period from 20th December 2019 to 7th February 2020 has to be excluded. So if he filed it on 27th February, right? You filed the
27th February.
তাহলে period of delay from 8th August 2019 to 19 December, 9th August 2019 to 19 December 2019, তাই তো? অ্যাপ্লিকেশনটা করলো তো 20 তারিখ। তাহলে দিস ইজ না 7/12 নয়, 7/2 থেকে 7/2 থেকে 27/2। আচ্ছা 28/2।
August to December.
5 months. And there was how can there be a delay of 197 days?
And 60 days, my lord, will be excluded, my lord, within file, my lord.
অনেক
150. Yes, my lord.
Months and all.
Yes, ma'am.
From 8/8/2009 to 19/12/2000.
That is 5 months.
That is 4 months. 4 months. 11 days.
4 months 10
11
days আর কি।
4 months 10 days.
তার মানে কত দিন? 4 3s are 12, 130 দিন।
130 days.
আর 27 দিন আর 20 দিন।
7 to
150 দিনের দিকে approximately।
And 60 days will be deducted. That is statutory.
After deducting, we are making
Yes, yes, yes.
Now, what is the ground? Length of delay is
Yes, not sufficient cause.
Okay. Now, what is going on?
But my lord, but my lord, the order was not passed. Order was passed, my lord, 8/8/2019. But due to my lord, the tribunal, due to my lord, the DLRO never signed and transcribed the order. For that reason, my lord, the 38 days was taken time from date of filing of the second application. And it was got, filed an application 2012-2019 and got, my lord, 7/2. If it is
After 2 months it was.
after 2 months, if it is filed, my lord, 2-3 days sufficient.
How
2-3 days
How
sufficient.
does that help you? That period has been excluded from 7th of December, 20th of December to 7th of February. That period has been excluded.
You will not justify that, your that claim, that DLRO
But my lord,
had this order on a later date, but put the earlier.
put the earlier.
You will not be able to justify. In that circumstances, you
But
have to
yeah,
make
I'm
application for certificate of
my client, my lord told his learned clerk to file the application for certificate copy. He applied, but first application was misplaced. Thereafter, again, file an application, my lord, on 2012-2019, and thereafter got the same. That is the, my lord, explanation, my lord, in this application, my lord. And my lord, delay was not 197, that is 143 days delay, that is the maximum. That is the sufficient reason. And in this case, my lord, the merits of this case, there is a merits of this case. First suit was filed, suit was decreed in favor of me, and the arrest record is erroneous, 1962. Thereafter, the state of West Bengal also made party, my lord, in 1981, and the state contested the suit, and suit was decreed, but that is binding upon the state. But my lord, when the merits is case, my lord, when the merits is case, that should be meritless. That should be, my lord.
your explanation is sufficient enough or not.
Yes, my lord.
Lordship kindly takes up page
supplementary
83.
affidavit.
That is the delay application, my lord, that has been filed.
I have sufficient reason, my lord, if you lordship
He
supplementary affidavit
stated
also
that there is
stated.
a delay of 197 days. There this now
Says
no miscalculation. There it has cropped out, my lord. Why this is 197 as your lordship was
And a
calculated right now?
supplementary affidavit, my lord, stating the facts, my lord, if you lordship.
Out of the part.
Yes, my lord. That is, my lord.
For delay in filing application for certificate.
Certificate copy.
That is the
But
sole
my lord,
ground
when the
taken, but
suit
there is
was-
nothing on record as such.
It was meritless. That's this is a meritorious suit, kindly see, my lord, if you lordship. That, my lord, state of West Bengal, my lord, was made party against the order. He contested the suit. My lord, suit was decreed.
Taken that is COVID-19, but that came much later.
Mr.
The filing.
It will be hard on merits.
Hard on merits.
I am not on that, my lord. I am placing the facts actually. What I am supposed to do, my lord, two grounds ultimately has been taken up.
Mala fide. There is no
I am not on that. But I have to.
Is directed
They are
against the
technical.
order, but against the order. It is September 2023. First by the largest tribunal in OA number.
Filed in connection
First in an application for confirmation of delay number
274
of 2024
20
and 20
filed in connection
number 612 or 2022.
no 20
2020. Whereby the application for confirmation of delay was dismissed
upon exchange
of affidavit
Kindly, if your lordship kindly turns to page 107 only, my lord, only I'll show that relevant paragraph, why it has been dismissed. That explanation has been given. 109
Yeah,
of
yeah.
that.
Learned advocate appealing for the president submits that the order which was assailed before the tribunal in OA number was passed on
8th of August
8th of August 2029.
90,
19.
page 85 এও দিছে।
But on the very same day, the order was not duly signed. He submits that the clerk of the
page 86
advocate clerk,
86 টা দেখো না, page 86 টা দেখো, ওখানেই অ্যাপ্লিকেশনে বলা আছে। প্যারাগ্রাফ 3
to submit that clerk applies for the certified copies. But the same, but the clerk concerned lost the received copy of such application, and ultimately the concerned clerk made application for obtaining the certified copy of the aforesaid order on 20th December 2019, which was obtained by him on 7th February 2020, and on 28th February 2020, the original application was taken. He submits that since the receipt of the application was lost by the clerk, there was a delay in preparing the original application. He submits that the matter, there is a merit
the applicants, the petitioners are the issued persons, and they can
he further submits that the petitioners are the illiterate person, and they should not be forced to suffer due to the
latches on
the part of the
dealing clerk.
To submit that matter is
এটা जो आगे একটা application করেছিল, where did you say that you previously applied?
Supplementary video stated, specifically stated, my lord, paragraph. Paragraph 3, if you lordship, page 2.
This you did not state in the tribunal.
Tribunal, my lord, if you lordship, copy of the counterpart of the application, it is also, but it was not, that is draftly.
Page 85 is your statement. Yes. Where have you said that the first application
Only
receipt
stated,
was
my lord.
lost?
Yes, my lord. It is not, my lord. Drafting is very poor.
My lord, thereby the specific finding at page 109.
Yes.
Supplementary video is specifically stated. Paragraph 3.
That the petition has a big chance of success in the original application. And on such technical ground, petitioner has every chance of success in the original application, and on such technical ground. But it would not be justified to throw away the petitioner from the result of the judicial institution by adopting a hyper-technical approach. So he submits that the delay should be controlled and petitioners should be placed from that to place the ordinary action before the law. Stop. Mr. Ganguly, may I distinguish the submission made on the part of the petitioner. We submit that there was a intentional laches on the part of the applicant. We submit that the delay caused in preparing the original application has not been properly explained and was not properly stopped. Other learned advocate from the court stop that. Law of limitation was enacted not to destroy the right of the parties, but to ensure so the party seeking his grievances can approach the judicial institution and the court without causing any unnecessary. An institution should make an effort to decide the issue placed before the authorities. And thus, in the judgment of Karchi reported 1987, Supreme Court page 135, the Honorable Supreme Court was pleased to hold that the expression sufficient cause is to be construed in the manner hidden. Now, while dealing with such application, or while dealing with such application, whether dealing with such application for the purpose of dealing, or while examining the making an examination as to whether the explanation given to us the dealing was sufficient or not. But both make an report whether there was a narrative or intentional delay on the part of the party seeking remedy before the judicial institution, or the party has adopted a dilatory practice or due to causing such thing, whether there is a change of situation or not, and the situation has gone to such extent the condonation of delay will seriously prejudice the other party. So, on close, we started scrutiny of the materials placed before us. We do not find any material to infer that the petitioner resorted to delay on practice. Consequently, we are of the view that the tribunal should have allowed the application for condonation of delay. Accordingly,
may I
delay
just
delay caused by the petitioner in preparing the original application before the tribunal Hon'ble, the order is set aside, the original application is admitted. Original application being such and such is restored to its original file and number. The learned tribunal is directed to decide the original application on merit as expeditiously as possible without granting unnecessary adjournment.
my lord, we'll humbly pray, my lord, one addition, my lord, because the specific prayer that has been made in before the tribunal and here also is that the order was not signed and therefore was not supplied. My lord, therefore the allegation is against us. But kindly, my lord, we are not nothing.
We without examining as details whether the point taken by him is justified or not, we are seeking that there is no intentional.
There
has not resorted to military tactics with a foul motive or anything.
Absolutely.
And hence we.
But the only issue is that we are not
Grateful
admitting
for
these allegations because there is a specific allegation in spite of the application being first application being made, we are not supplied.
Without calling for epidemics from the state, that the environments.
What argument do you want to make, Mr.
Well, there is a specific allegation that in spite of the first application being made, we as authority has not signed, we cannot give the copy.
That you have denied, Mr.
Well, that portion should be taken care of. Well, otherwise, this will remain.
You have denied the disputed your content.
Well, that is what
So
I'm saying.
naturally on affidavits it was decided your statement is already on record. It is not a fresh addition is required.
But here also we have not used the affidavit. Here also they are saying that only one issue that we have made the first application that we have not supplied the copy. That is the only delay. In fact, in the supplementary also that allegation has been leveled below.
Submits that the first application was not even submitted by the
My lord.
was not even submitted by the petitioner before the competent authority for availing the certified copy. দিয়ে দাও তাহলে ওটা কেটে দাও ওর ডিজাইনটা যেহেতু তুমি একটা ঠিক আছে হ্যাঁ
Okay.
Next that go not at all সেটা তুমি বলে দাও ওইটা যেটা বললাম কেটে দাও কেটে সাহেব মিস্টার গাঙ্গুলি ফার্দার সাবমিট
Petitioner has not made any application for obtaining certified copy.
Prior to no have made no application prior to the application dated 20th December. No, ও বললো না আমি রিসিপ্টটা হারিয়ে ফেলেছি সেটাই বলেনি
His claim of certified copy of 8th August is not there.
Dated 20th 12th 2020.
That is the only application.
Yes, that is what
Yes,
we are
yes.
disposed of.
Because as he has only got that ground over there.
বললেন তো
Filed for obtaining certified copy prior to the application dated 20th 12th 2020.
হ্যাঁ
এটা
yes next
I'm grateful.
grateful চলো দেখে দাও চলুন তাহলে
But we are defaulters in so far as item number 13 is concerned. It was a returnable motion.
Yes.
And
what do you want, Mr.
it has been adjourned for 2 weeks. Not in fact, we got it mentioned and got it upgraded.
So that is why
That
we are,
kindly not, don't punish us not,
this
by
is
2
the
weeks. Not
proper
this.
conduct, Mr. Mojumdar.
Not I.
We upgraded the matter, we fixed the matter. Then if you don't appear,
Just because not 8 to 12 was called in quick succession. Not I couldn't overtake my age. Not from that.
Huh?
None appeared. None appeared.
My lord, my lord, my one matter.
Wait. So, Mr. Mojumdar, it will appear at that position after 2 weeks. What is the problem?
Kindly recollect not that.
We don't know whether any such advocate was there.
None appeared. Mr. Siddiqui was there in the centenary building. Mr. Learned Advocate General was also there. Mr. Supradim Dhar was also not there.
Supradim Dhar was there.
Not for after this matter.
Okay.
And I met him in the corridor. The learned advocate general was instructed to come back with the
not this week করে রেখে দাও, next week.
grateful team.
My lord, one matter,
No mentioning now.
24 is
Yes.
running for long days.
Pardon?
Item number 24 is running for long days.
What is your problem, sir? What do you want?
Actually, if it is
24 what? What do you want?
tomorrow, if it is fixed at top of the limit.
Yes, sir.
May it please your lordship.
Yes. Yes.
Milord, I have addressed your lordships, Milord, on first day, Milord, on the points of demo. That's over. Milord, second, Milord, I have addressed your lordship, Milord, on the grounds on which the constitutionality of a statute can be challenged. But that also, Milord, I have completed. Third, Milord, I have taken or dealt with one of their points in regard to fraud on constitution.
Yes.
That's also over. Milord, I have reserved, Milord, two of my points of demo, which I have said that I'll argue after merits. Then, Milord, on the last day, Milord, I intended to start with the Sachar committee report, which would throw light on, Milord, the situations of these OBCs. Milord, we had, Milord, handed up, Milord, pen drives, Milord, for your lordship's consideration.
Mr. Dotto, the
Yes.
last judgment which you referred to
Yes, my lord.
regards your challenge, was it 97-8 SCC or 2011-5 SCC?
2011 5 SCC 464.
Yes, that was the last judgment.
That was the last judgment that I had cited on the last occasion.
Yes,
That's right.
yes.
Yes. না সেটা অন্য পয়েন্টে
And
97
which
হচ্ছে
is
fraud on constitutional.
18.
Huh.
Mr. Dotto, with this, can you that judgment where you showed that recommendation, even if it is construed, it cannot be construed to be binding upon the state, but in the event the state disagrees, then reasons needs to be given. Will you please ask your junior, that paragraph was placed?
Yes.
Just for, most probably it was in 2014 volume 15 SCC 308. No,
No.
that is 1450. Totally it is not that. All right, just if you get it.
Yes.
Yes, you are placing the Sachar committee.
Yes, I'll start, Milord, today placing the Sachar committee report.
Yes.
Milord, fundamentally, Milord, your lordships would find that there have been 4 reports or 4 committee reports. The first one is Kalekar report, which was in 1955. The second one was Mandal Commission report, Milord, of 1980. The third is Sachar committee report made in 2006. And the fourth one is Justice Ranganath Mishra report in 2007.
Correct.
Milord, these are, Milord, the 4 reports which deal with, Milord, backward classes, irrespective of whether it is Hindu or Muslim.
Yes.
Milord, your lordships may kindly have a look to, Milord, page 2, after the index and forewords and glossary. But at the bottom, my lord, your lordships will find where the page numbers. Initially, my lord, these are in Roman numbers. After Roman 22, my lord, thereafter.
Yes.
Page number 2. Where there's a heading, mandate of the committee.
Yes.
In the second paragraph, a wide variety of policy initiatives and programs have been launched by successive governments to promote the economic, social and educational development of the minority communities in India. However, while the Muslims have no doubt made some visible progress, the perception remains that the economic and educational gap between the community and the rest of the SRCs has been widening. Once the development deficit amongst Muslims is assessed, policy interventions will need to be reviewed in the context of available evidence and new initiatives launched to grapple with the marginalization of Muslims in the social, economic, and political space. Given this background, the Prime Minister constituted a high-level committee for preparation of a report on the social, economic, and educational status of the Muslim community with a notification number so and so. The terms of reference are reproduced below. A, to obtain relevant information from department agencies of the central and the state governments and also conduct an intensive literature survey to identify the published data, article and research on the relative social, economic and educational status of Muslims in India at the state, regional and district levels to address inter alia the following questions. Millard, kindly skip over, Millard, 5 bullet points. Please take the 6th bullet point. In the next page, what is the proportion? This is where, Millard, we need to draw your lordship's attention. What is the proportion of other backward classes from the Muslim community in the total OBC population in various states? Are the Muslim OBCs listed in the comprehensive list of OBCs prepared by the National and State Backward Classes Commissions and adopted by the central and the state governments for reservation for various purposes? What is the share of Muslim OBCs in the total public sector employment for OBCs in the center and in the various states in various years? Now, Millard, where there is a statistics in the next page, that is page number 5, with the heading.
Mr. Dostur, kindly pause for a moment to answer this. Has this report been accepted by Parliament? It is rejected as far as I...
Millard, Millard, I have tried to find out, but I couldn't. Maybe.
Which reason the Ranganath Mishra Commission was also brought in. Otherwise, it would have been accepted straight away.
May I say this? Ranganath Mishra Committee did not deal with this. Ranganath Mishra Committee dealt with the Dalits only.
Even the Ranganath Mishra
Yes, I'll try to find out.
Did not come to West Bengal at all. That they have admitted in the commission report.
Yes.
But the Sachar committee report, please address this. Please, I'm sure your junior will find out.
But I'll try to find out because we have.
If the report has not been accepted by the Parliament, to what extent can we?
Yes. Yeah, I quite follow.
Please.
Yes. Now, kindly take me, Lord, page 5, para B. Data from the National Sample Surveys. NSSO 55th and 61st round data have been used to analyze issues relating to employment, education, consumption patterns, and levels of poverty. Unlike the census, NSSO data allows identification of other backward classes. The SRC set defined basis on the NSS data are as follows. All or total population, all Muslims, Muslims general category, Muslims OBC, about 1.5% of the Muslim households reporting themselves as SC/ST have been included in this category. Then, Millard, Hindus, I don't trouble your lordship because since, Millard, we are not dealing with it. Millard, what Google says, Millard, as per the query of Justice Mantha, Google says the central government has accepted 72 recommendations of the 76 recommendations listed by the Sachar committee. So I need to find out which of the 4 has not been accepted.
Central government.
Yes.
But what about, was it placed in parliament?
Possibly so, because otherwise where the. But I'll make some research on that. I'll make some research on that and come back, Milord. Now, Milord, Milord, after skipping over a few pages, please come to Milord page 192.
I'll tell you honestly what's bothering us.
Yes.
Is if the Sachar committee report was so sacrosanct, and it is, and the central government, as you say, has accepted it, then the commission, at least in the recommending the first 77 classes in 2010, subsequently, at least they could have referred to the Sachar committee, or they could have, it would have made life things easy for a lot of people.
Correct.
Page 192.
192.
Yes, where you are placing?
Milord, again, Milord, by going by the Google, Milord, without. This is Wikipedia. This was placed before the Parliament, Lok Sabha, on 30th of November 2006.
And passed? Accepted?
The report highlighted so and so. The report made observations on so and so, highlighted such and such, concluded this, such a committee report in this. আচ্ছা কোথায় পাচ্ছিস রে আচ্ছা
Very good. We'll come to that. We'll come to that. No problem.
I'm sorry, Milord. Please come to Milord page 189.
Yes.
Milord, first is introduction. Please take the 6th line, the sentence starting with the present attempt.
Yes.
Is to compare the socio-economic status of Muslims who are not listed as OBCs, named Muslim general, and do not avail reservation of any kind with those who are OBCs. The status of both these social groups is also compared with those of Hindu OBCs who form bulk of the OBC population in the country. The attempt is to comprehend the extent of respective relative deprivation. The comparison is now facilitated by the NSSO that from its 55th round onwards has begun collecting data on Muslims which can be disaggregated into socio-religious communities. At the outset, it must be noted that the NSSO data is self-reporting, and particularly so in the case of OBCs, it is contingent on the awareness of the respondent of his or her social status. The primary intent of this chapter is to look into the Muslim OBCs from the perspective of affirmative action. Therefore, the most pertinent categories like Hindu OBCs and Muslim OBCs. However, in order to understand the intra-community variations, it is necessary to provide comparative data regarding the rest of the Muslims referred to as Muslim general from now onwards. This chapter draws from a wide array of data, both secondary and primary. Sociological studies on Muslim social stratification has been drawn upon to comprehend the complexity of castes or biradaris amongst the Muslims in India. Studies on backward class movements, analysis of Constituent Assembly debates, and various landmark judgments of the Supreme Court and the High Courts have been of great help in understanding the historicity of the emergence of the category other backward classes. In the wake of absence of, I'm so sorry. I'm sorry, Milord. কথাটা হারিয়ে গেছে তার। এই না না পেয়ে গেছি পেয়ে গেছি পেয়ে গেছি। Yes, I'm sorry, Miller. Understanding the historicity of the emergence of the category other backward classes in the wake of absence of caste enumeration after independence, much of the empirical data on Muslim OBCs, their share in population, in education and in public employment have been drawn from the 61st round of national sample survey that includes OBC amongst Muslim as a category for analysis. For the sake of comparison, data from the 55th round is also used. Kindly skip over that, that is not important. Then please come to Miller, paragraph number 2. The emergence of the category other backward classes. The constitutional reference to the term backward classes finds place in articles 15.4 and 16.4, wherein the state is empowered to make special provision for any socially and educationally backward classes of citizens. Yet, unlike the categories of scheduled castes and scheduled tribes that were distinctly defined, the category backward classes remained unambiguous. The term had come into usage during the British period, but with a variety of reference and evidently without any clearly specified parameters regarding the inclusion and exclusion of groups clubbed as backwards. In its early usage, the backward classes was an all-encompassing category that would include the underprivileged and the marginalized castes, tribes, and communities. The term was used as far as 1880 to describe a set of groups also called the illiterate or indigent classes entitled to allowances for study in elementary schools. But in the next paragraph, Miller, kindly skip over the first part. Please come to Miller, page number 191, the fourth line from the top. The sentence starting with, in this case, the distinctive term, that is backward classes, that came into usage was other backward classes. In both usages, however, the point of reference was largely Hindu social structure. This is important. The question of backward groups from among the religious minorities remained absent in the debate until delegates belonging to such groups raised the issue. Thus, Muhammad Ismail Sahib from Madras sought clarification whether the term extended to backward classes of minority communities. We are pausing here for a moment. Now that your lordships find that most of the classes which has been included being Muslims, one of the reasons is, as it appears from this report, that all along OBCs was thought to belong to the Hindus, which are already included in various lists, state as well as central. I'll give you lordships those figures later on. But suddenly it struck to somebody that there is other backward classes amongst the Muslims also, once it was raised by this gentleman. Therefore, my lord, now, my lord, proceeding forward, so only one more sentence. Therefore, the fact that mostly Muslims are now being declared as the OBCs is not that striking a feature compared to the historical development in earmarking the other backward classes in the relevant list.
Get this, that until this question was asked,
yes,
OBCs were always confined to Hindus. That wasn't the object of 16.4.
No, these are all Millard 15.4 exercises. What we are now looking into is 15.4 and 16.4 exercises after these were brought in the constitution, or rather, Millard, the states.
Difference between a 15.4 exercise.
Right. Definitely. 16.4 is employment, and 15.4 is making special measures.
But backwardness, there is similarity to some extent, but then 16.4 would have to be a more stringent test.
Right.
Would have to be followed.
Right. Definitely. Then with Article 340 empowers the state to appoint a commission to investigate into the condition of socially and economically backward classes. At the all India level, 2 such commissions have so far been appointed. I skip over this paragraph that I've already told your lordships. Kindly take the next paragraph. The usage of classes instead of caste in constitutional reference to OBCs, that is in 15.4 and 16.4 and 341, has led to mainly legal wrangles and disputes. However, the courts like the two backward classes commission accepted the caste as a basis of classification. In so and so, the Supreme Court upheld the list of Hindu castes declared as backward by the Madras government. This was further confirmed in the Ramakrishna Singh versus so and so, in which the Mysore High Court held that the classes included persons grouped on the basis of their caste. Now, I'm going to skip over a few lines. Please take the next page, the second line. The caste basis was further clarified in 1968 in so and so, wherein the Supreme Court held that a caste is also a class of citizens if the caste as a whole is socially and economically backward. This was reaffirmed in so and so when the Supreme Court scrapped the Andhra Pradesh High Court ruling and allowed the use of caste as a determinant to define backwardness. In the celebrated Indra Swani, the 9 judges bench rejected the economic criteria as the determinant of backwardness. The court upheld the concept of caste. A caste can be, and quite often, a social class in India. On the question of backward classes amongst non-Hindus, the court held that they should be identified on the basis of traditional occupations. Therefore, as of Indra Swani, that is 92-93, there was an endeavor for a future exercise to be undertaken to identify these classes. Now we are skipping the next paragraph. The third heading is Muslim OBC, a profile.
Page 195.
Page 192.
Third paragraph.
Yes.
Profile.
Yes. In profile, please take the sixth line. Now, this is going into the origin. The present-day Muslim society in India is divided into 4 major groups. One is the Ashrafs, who trace their origins in foreign land such as Arabia, Persia, Turkestan, and or Afghanistan. 2 is the upper caste Hindu who converted to Islam. 3 is the middle class converts whose occupation are ritually clean. And 4, the converts from the erstwhile untouchables, that is Bhangis, scavenger, Mathur, that is sweeper, Chamar, tanner, dome, and so on. So these are 4 broad classes of Muslims in India. Then they are brought into 2 major groups now. These 4 groups are usually placed into 2 broad categories, namely the Ashrafs and the Ajlaf. The former, meaning noble, includes all Muslims of foreign blood and converts from higher castes, while Ajlaf meaning degraded or unholy embraces the ritually clean occupational group and low-ranking converts. In Bihar, UP, and Bengal, Sayyads, Sheikhs, Mughals, and Pathans constitutes the Ashrafs, that is the foreigners. The Ajlaf are carpenters, artisans, painters, graziers, tanners, milkmen, etc. According to the census of 1901, the Ajlaf category includes the various classes of converts who are known as now Muslims in Bihar and Nasya in North Bengal. It includes various functional groups such as that of Jolaha or weaver, Dhunia or cotton carder, Kulu or oil presser, Kunjra or vegetable seller, Hajam or barber, Darzi or tailor, and the like. The 1901 census also recorded the presence of a third category called Arzal. It consists of very lowest castes such as Halalkhor, Lalbegi, Abdal, and Bedia. Therefore, Mulad, we finally get three groups. Asrafs, Milord, they are the foreigners or the higher one. Then we have Ajilabs, and Milord, last is Arzal. The last of the three rather, where your lordships would find, Milord, is recognized based on their traits, their occupation. And this is class.
Yes.
Milord, classes are fundamentally, as I've understood, Milord, as I go ahead, are, Milord, determined primarily on traits and their occupations. Then we have the next paragraph. Similar pattern of descent based social stratification is discernible in other regions as well. In Kerala, the Moplas of Malabar are divided into 5 ranked sections called the Thangals, Arabics, Malabaris, Pusalars, and Oceans. The Thangals trace their descent from the Prophet's daughter Fatima and are of the highest rank. Next in rank are the Arabis, who claim descent from Arab men and local women and retain their Arab lineage. The Malbaris are the next in rank. They have lost their Arab lineage and follow matrilineal descent. The Posalars are the converts from Hindu fishermen called Mukkuvan, the new Muslims. They have low status. The Osans are the Barbars, and by virtue of their occupation, they rank lowest. In Andhra Pradesh, a field study conducted in 1987 found hierarchically arranged endogamous groups amongst Muslims. At the top of the ladder were those claiming foreign descent, that is Shayeds, Sheikh, Pathan, and Labai, descendants of Arab traders who took native wives. At the lowest level were groups with unclean occupations, that is Dudekela, that is cotton cleaners, Hazam barbers, Fakirs Budki, that is mendicants. Muslim groups currently bracketed under the category OBC come essentially from non-Ashraf sections of Muslim population. They are converts from the middle and the lower caste Hindus and are identified with their traditional occupation. A study of a village in Uttar Pradesh could identify 18 such groups. For examples, Juhalas, that is weavers, Mirasis, singers, Darzi's, tailors, Halwais, sweet makers, Manihars, bangle makers, and so on. The 1911 census listed some 102 caste groups amongst Muslims in Uttar Pradesh. At least 97 of them came from non-Ashraf category. Many such groups, such as Rajputs, Kayas, Queries, Koris, Kumhars, Kurmis, Malis, Muchis were common among both Hindus and Muslims. Since the Constitutional Scheduled Caste Order 1950, popularly known as the Presidential Order 1950, restricts the Scheduled Caste status only to Hindu groups having unclean occupations, their non-Hindu equivalents have been bracketed with the middle caste converts and declared OBC. Thus, the OBC amongst Muslims constitute two broad categories: the halal khors, helas, lalbegis or bhangis, scavengers, dhobis, washermen, nais, and hajams, that is barbers, chicks, butchers, fakis, beggars, etc., belonging to the arzals, are the untouchable converts to Muslim that have found their way in the OBC list. The momins or julahas, weavers, darzis or idris, tailors, rains or kunjaras, vegetable sellers, and ajlafs or converts from clean occupational castes. Thus, one can discern three groups. Now, this is the three broad groups, my lord, for the OBCs. For amongst Muslims, Muslim OBCs. One is those without social disabilities, that is the ashrafs or the foreigners. Two, those equivalent to Hindu OBCs, that is the ajlafs, and those equivalent to Hindu scheduled castes, that is the arzals. Those who are referred to as Muslim OBCs combined 2 and 3. So one is left out, or the foreigners are left out. Now, please come, your lordships may kindly take me note, page number 200.
So which one is left out, you said?
The
This
ashraf.
Ashraf, yes, the last, thus one can discern three groups
Three
among
groups.
Muslims.
Yes,
One without any social disabilities, that is the Ashraf.
right.
Then is the equivalent to Hindu OBCs, that is Afzal.
Ajlafs, that is ajlafs.
Ajraf.
Yes.
And the other one is Arzal.
Arzals.
Yes.
Then it says those who are referred to as Muslim OBCs combined 2 and 3. Or in other words, ajlafs and arzals.
Yes.
But then, my lord, before going to 200, please take me to page 195, the second paragraph. But this is a gist of, my lord, the Kaka Kalelkar Commission and Mandal Commission. Please take me to the second paragraph at page 195. The second All India Backward Classes Commission, the Mandal Commission, submitted its report in 1980. The commission involved 11 indicators, a mix of caste and class features, for assessing their social and educational backwardness. The commission saw castes as the building bricks of Hindu social structure that, despite the constitutional commitment to establish a casteless and egalitarian society, had continued to persist. It arrived at an exhaustive list of 3,743 castes that were declared as backward. The commission, in principle, accepted that occurrence of caste or caste-like feature was not restricted to the Hindu society. Its influence was also amongst non-Hindu groups, Muslims, Sikhs, and Christians as well. Based on the data provided by 1931, it is census away, Janina.
Census and fled survey.
Yes, I think there's some census, whatever, some survey, survey and field survey conducted at the instance of the commission. At least 82 different social groups amongst Muslims were declared as OBCs. The commission, however, desisted from employing caste as a criteria to identify non-Hindu OBCs, as these religions were totally egalitarian in their outlook. The commission, however, refrained from invoking poverty as the sole criteria. The rough and ready criteria that the commission evolved had two conditions. A, all untouchables converted to non-Hindu religion. In the Muslim case, they are the arzals. B, such occupational communities which are known by their name of their traditional hereditary occupation and whose Hindu counterparts have been included in the list of OBCs. Among Muslims, this comprises the Ajlaf category. But what is to be known, Milord, in the Milord, highlighted in the background of the grievance over here is B, the third line. The Hindu counterparts have been included in the list of Hindu OBCs.
Yes.
Then, Milord, please take the next paragraph. By clubbing the Arzals and the Ajlafs Among Muslims, in an all-encompassing OBC category, the Mandal Commission overlooked the disparity in the nature of deprivations that they faced. Being at the bottom of the social hierarchy, the results are the worst of and need to be handled separately. It would be most appropriate if they are absorbed in the scheduled caste list or at least in a separate category, most backward classes carved out of the OBCs. But this is only a proposal. Now, kindly, Milord, your lordships may skip over a few pages. And Milord, kindly come to Milord page number 5. I'm sorry, page number 200, heading number 5 after the table.
Page 200, huh?
200.
Yes.
This is again very important. The heading itself is important and indicated that why so many Muslims have been declared. Muslim OBC is not included in the state and the central lists of OBC. Reservations for OBC has a long history in the states at the center. As the recommendations of the Mandal Commission came to be accepted, the central list of accepted the central list of OBCs in the initial phase was prepared by employing the principle of commonality. Thus, only those caste communities listed both in the state list as also in the list prepared by the Mandal Commissions were included in the central list. It is not surprising, therefore, that a number of caste communities that had either been listed only in the Mandal Commission list or only in the state list were left out. This discrepancy was expected to be solved once a permanent body, namely the National Backward Classes Commission, was formed. The NCBC formed in 1993 had issued a set of guidelines based on social, economic and educational indicators for caste communities to be included in the central list of OBC. The discrepancy between the two lists, central and the state, is still evident. This is a general complaint and not confined to Muslims alone. There are many OBC groups, irrespective of their religion, that are present in the state list but missing in the central list. Madhya Pradesh, for instance, has 91 social groups listed as OBCs in the list recommended by the State Backward Classes Commission, but only 65 such groups have found entry in the central list. Uttar Pradesh has 79 castes in the state OBC list, but only 74 in the central list. In Rajasthan, there are 74 castes in the state list, but only 65 has been accorded OBC status in the central list. Such discrepancy also applies to the Muslim OBCs. In Madhya Pradesh, for example, there are 37 communities listed in the state list as Islamic groups. However, only 27 of them found in the central list. In Bihar, after the recent revision of the list, there are 17 OBC groups that have been found in the central list. 6 of them are exclusively Muslim, namely Fakir Diwan, so-and-so, so-and-so, so-and-so. In Uttar Pradesh, 2 Muslim groups, such and such, have not found entry in the central list. In Gujarat, the Muslim groups, such as the Jilaya, Tariyatai, Mansuri, Arab, Sumra, Tarak, Kalal, and Bavaiya are listed in the state backwards list, but not in the central list. Similarly, many Muslim groups in Maharashtra, such as Mansuris, Pan, Farosh, etc., is important. The list of OBCs prepared by the state governments has also missed many underprivileged and caste communities. There are few groups amongst Muslims that have found place in the central list, but yet to be included in the state list. This is another information which also requires your lordship's consideration in the backdrop of this case, that included in the central list but not in the state list. Kalwars in Bihar, Mansuris in Rajasthan, Atishbaz in Uttar Pradesh, Rains, Kalwars, Rangwas and Churihars in West Bengal are examples of such Muslim groups. There are still a number of Muslim groups that have neither been included in the state list nor in the central list. These groups can be identified using information collected by the Anthropological Survey of India under its People of India project. In Gujarat, for instance, the project found 85 communities, of which at least 76 are non-ashrafs. In the central list, however, only 22 of them have found entry, whereas in the state list, there are only 27 Muslim groups. In Bihar, according to the project, there are 37 caste communities that have counted as non-ashrafs. However, only 23 are in the central list. In Uttar Pradesh, the project lists 67 communities amongst Muslims, 61 of whom are occupational groups. Both the state and the central list of OBCs only contain only 32 of them. Then SC status, Millard, I skip over, Millard, because we are not dealing with SC. Now, please come to Millard, heading number 6 at page 202. Empirical situation.
This is of which year, Mr. Dutta?
Millard, this is of 2006.
2006.
Yes.
Yes. Page 202.
202, Millard, the heading empirical situation. In this section, attempt has been made to quantify the relative deprivation that the Muslims in general and Muslims OBC in particular face. Different variables have been employed, for instance, male and female work participation, representation in various levels and sectors of public employment, salaries and wages, per capita income, incidence of poverty, urban and rural landholding, relative share in the education, etc., to ascertain the status of Muslims OBC vis-a-vis their Hindu counterparts and also the non-OBC Muslims or Muslim general. Most of these variables indicate that the Muslims OBC are significantly deprived in comparison to the Hindu OBC. Population distribution amongst the Muslim OBCs. For determining population distribution, the decennial census operation in India is the most credible source. In our task of determining the share of Muslim OBCs, however, the census exercise is inadequate, as since independence, enumeration across castes or biradaris have been shelved. Such a decision has only led to speculations, claims, and counterclaims that lack precision. In some of the states, however, the State Backward Classes Commission have made attempts to figure out the population of various castes listed as OBC in their respective states. But one must remember, most of such surveys date back to more than a decade or two. Further, since all the state governments or the state level backward classes commissions have not undertaken such a survey, no all India estimate can be made from them. Relying on the data provided by the 1931 census, the Mandal Commission estimated the OBC population of the country to be 52% of the total population of the country. It is assumed that it assumed the share of OBCs amongst the non-Hindu, Muslim, Christians, and Sikhs religious groups also to be in the same proportion. Thus, the share of non-Hindu OBCs in the total population of the country was projected at 8.40%. Given the fact that 1931 base is itself contentious, this estimate needs to be further examined. The Mandal estimate is also unreliable because a large number of caste communities that were included in the Mandal list have not yet found place in the central list of OBCs. More recently, the National Sample Survey Organization, from its 55th round onwards, has begun providing self-reporting data across the broad categories of OBCs among various religious groups. Thus, the share of Muslim OBCs in population, employment, or education can now be gathered from it. The count of individual castes, their share, however, is still not available. In our analysis, the population share of Muslim OBCs will be largely dependent on the National Sample Survey 65th round.
Mr. Doctor, this practice itself ought to have been accepted, ought to have been adopted by the commission.
Yes.
Your argument, if we understand, is that amongst the OBCs, it is not that only the Muslims are being highlighted as has been argued on their behalf.
Right.
But this Sachar committee report, how these principles have been applied by your commission in state.
My lord, may I very humbly submit this? It all depends upon, my lord, the scheme of the statute. Where the scheme of the statute is, if you want, you apply. Then there would be certain ABCD steps undertaken, and thereafter either the one who applies or the caste or the class who applies is either declared to be an OBC or not declared to be OBC. Now this application is religious neutral. Now what is to be seen in the background of this history and the statute is, number one, from various sources your lordships would find that initially the concept or the conception of OBC prevailing amongst the Hindu was almost not noticed. Therefore, it was fundamentally confined to declaring Hindu OBCs as OBC.
Right, but what is the disclosure of such reason by the commission?
May I say this? Yes. May I say this, my lord? But my very humble approach to the problem is that simply because, say out of 100, just take an abstract figure. Say out of 100 applications received, because the statute is not that a body will go, inquire and declare. That is not the scheme of the statute. The scheme of the statute is otherwise. That if I feel that I belong to a class which has not been declared as an OBC, I will go and apply. That is why, Miller, this
The commission supposed to do thereafter.
yes. Now, after receiving these complaints, I'm sorry, Miller, the application, but kindly look into the affidavit, Miller, apropos your lordship's query. Please have a look to the combined AO, Miller, on which, Miller, much vivace has been raised.
In 1160.
Yes, in 1160.
Affidavit to the 1160 it is stated at commissioner একসাথে affidavit.
But my learned senior brother was asking Mr. Dotto.
Yes.
Is again first the announcement by the chief minister.
Yes.
And the commission follow suit.
Yes.
To fit in the hat, as Mr. So and so was using.
Yes.
And the hat this hat made to fit in the head or head made to fit in the hat. And what is being argued across the bar right now is also a justification of what the commission has done.
Yes.
Whereas this ought to have at least they come on affidavit first, which it has not. There's no reference to such a committee report. Or even for that matter, the commission's own reports. I've gone through the website of the commission in respect from right from 1993 all the way up to 2009. We found prior to this there were 66 castes and thereafter 77 castes have been included in 2010. Chief Minister's announcement, the Commission's recommendations, and forthwith inclusion. The speed at which it was done, number one. Number two, you are saying application, the scheme of the act, application, and the commission gets launched thereafter. Your affidavit has been placed repeatedly by 3 successive advocates general, where you have indicated that you have done so much survey, you've done so much this. This report has been received by the commission from your people or whatever. It is absolutely clear from there that whereas the commission has the power of a civil court, it does not examine even the persons who went to conduct the survey. At least their statement should have been taken on oath. the reports in respect of each caste or each each class that has applied
Yes.
is accepted as sacrosanct, not supported by affidavit. Admitted position is the entire population of the state has not been surveyed. These are the admitted positions that are clear from your own website in the commission. You have gone through it in substantial detail. So in the backdrop of this, when there's no discussion even or reference to such a committee, how much can we rely upon this at this stage?
Milord, with respect, Milord, the trend of argument is more prejudicial than, Milord, taking note of the history. But this is a case which is not to be looked into, Milord, from the point of view of the administrative law, divorce the background. Please consider this.
We are not sitting in appeal.
Yes, that's why I say.
We don't wish to either. We only want to say, see whether you have, let's say let's give you a straight example. In Indira Sani, Supreme Court has clearly said the survey is required to cover the entire population.
But I'll place Indra Swani after this, yes.
Your own reports say that you have conducted survey in respect of, let's say, 200 villages of one or 10 villages or 200 families. How do we give countenance this?
Milord, please, Milord.
From an administrative point, we are not sitting in appeal.
Right.
Please.
Right. Milord, what is sought to be portrayed before the court is a religious prejudice in the action.
Mr. Doctor, please, again a caution. We are not looking at
Yes, I quite appreciate, I quite follow.
We accept this argument from your side, although borrowed from Sachar committee, that there are, in fact, the very concept that only backward classes will be in Hindus is fundamentally wrong. There are backward classes. Why only Muslims? They're Christian backward.
Right, Sikhs are there, Buddhists are there.
Buddhist.
Yes.
Merely because they have converted, they don't suddenly improve their status
Right.
to sheikhs in the Gulf.
Right.
We are proceeding on that basis. We are only looking at the manner in which your commission has recommended and the state has accepted. This is all.
Milord, first is, as I was saying, Milord, the argument is based on a religious prejudice. Now, to develop, demonstrate, and prove a case of religious prejudice or bias or partiality, Milord, one has to indicate to the court what the other religion did not get but conferred to the favored religion. I put it in these brackets before your lordship.
Is that the only criteria first, Mr. Doctor?
Milord, we are, Milord, in a public interest litigation. That's why, Milord, my first point was whose cause is being espoused.
If it is individual interest, there is no question of any cause, individual cause coming in. We are looking at your classification of 2010 and 11 on its own merits, whether the classification was correct or not, whether it was driven by, given all these inconsistencies, whether we can add A to, let's say, L and say A to L, the chain is complete to indicate that it is driven for a religious.
Right.
That is one of the conclusions. But even removing the religion out, we are concerned with the manner in which the commission has acted and the state has accepted.
Milord, if your lordships keep the religion out, Milord, this writ petition has to fail on the first minute.
It will come at the end. I'm not saying it's
Yes.
the starting point.
Yes. But the starting point is the religion over here.
Because your chief minister said so
No,
at that
Milord,
point of time.
Milord, the chief minister may have said,
Of events after that.
Milord, could I say this, Milord? Milord, public announcements are made, Milord, those are, Milord, not to be taken into consideration,
Absolutely.
Milord, for the purpose of deciding the rights of person.
Right. Yes.
We are fully with you on that.
Now, Milord,
What about the follow-up action after that?
yes, Milord, now the question is, Milord, the next is, Milord, what jurisdiction has been invoked? But I can understand ex-Hindu community saying that I fulfill the criteria of OBC, but another Hindu convert of my same class,
He has been given.
of Muslim or Sikh or Buddhist, he has been given the status of a, say, Muslim OBC, but I, who has not converted into Muslim, have not been conferred with this status, and my application is rejected. What is most important is there must be an application and rejection of that application.
The 14 argument, Article 14.
Right.
What about 16 standalone?
Yes.
16
Now, yes, Milord. I'm very grateful to your lordships, Milord. In a, Milord, section public interest litigation, we are not on discrimination. We are not on competing rights.
Yes.
We are not on legal injuries. We are not on a right to enforce a legal right. We are here to first ascertain whether there is a public interest involved in the matter. Now, public interest may be a lot of things. Why people are spitting on the streets, public interest. But it has to be earmarked as a public interest, or it must come within the definition of a public interest.
That point was never raised, Mr. Dotto. It was when you came in the picture, you started afresh. My brother was ready that we must listen. We are listening to Mr. Dotto as the first appearance before us. But how can you rule out this point when it was previous persons were in? This was never the point taken.
Yes. Milord, could I say this, Milord?
There's another side.
Yes, Milord.
Let us take no discrimination, nothing. In a public interest litigation, you reserve, let's say, 77 classes to the extent of 17% of the service in the state. Aren't you depriving on its or especially who don't deserve it? Now, when it's done, let us say it's been, let us admit, I mean, for the sake of argument, that it is done incorrectly and contrary to law, manifest arbitrariness. Which means 17% of the state, I mean, public employment in the state is excluded from competition for the reserve class, for other classes, unreserved, SC, ST.
But this is the
only primary argument, and that's all we'll go for.
Milord, may I say this, Milord? This is one of the points of demur that I have reserved. That the more I argue the matter, the more my learned friends argue the matter, it's slowly transgressing into, Milord, service jurisprudence, where, Milord, PIL is barred.
Service jurisprudence, is this, it's not a case of joining an employment. It is per se deprivation.
16.4, yes. Yes.
Once you cross the 16.4 bar, then comes service jurisprudence. Employment, notification, entry, movement, termination, then post-retirement benefits. Then that is service jurisprudence. That is outside PIL. We are with you on that.
Milord, on the point, Milord, which possibly is troubling your lordships, that
you are not entering into that domain. You want the dispute to be thrown out at this stage.
Yes.
Because if you entered into the domain, the inaction on the part of the commission and state authority would be more explicit. That is why you want us to consider as to whether this, on the basis of a public interest litigation, we can go into the aspect of representation in government employment.
Right.
But 16.4 is independent, Mr. Dotto. Government representation that can certainly be shown by in a public interest litigation. How the bar comes in?
Milord, look at the points of demur as a point on merits also. let us not describe my points of demur as
Here, Demar.
here.
All right.
Now, with the disclaimer, may I proceed?
Yes.
Now, in a public interest litigation, what is required to be satisfied? And if your lordships are called upon to make a declaration or grant a relief, your lordships have to grant a relief in favor of the deprived. Please consider this. Who is the deprived here?
Is that you want to narrow our jurisdiction under 226 and PIL to that extent, Mr. Dotto?
Milord, PIL, Milord.
Can't we test your action of the state on its own?
May I say this, Milord?
Nobody is deprived. Let us start with that proposition. He is not deprived. Nobody is deprived. But your action is illegal. What do we do in such a situation? Shut our eyes? Nobody is deprived.
Well, first,
like passing interim orders, and nobody is prejudiced.
Yes.
The practice existed in this court.
Yes.
Nobody is prejudiced. Let us pass this interim order.
And sometimes, Milord,
The order that is to be passed, service is dismissed.
And Milord, sometimes, Milord, with a very bad case, we come and make an innocuous prayer that you injunct me from doing this.
Wonderful days we had in the 70s.
Yes. Therefore, my lord, even
reference to such are we understand.
Yes.
Now
but,
you can proceed on.
Yes, but I'll
Then
place
you
up.
finish it.
Yes.
Which page you are
Yes.
referring?
Before going to the next page, my lord, as your lordships were pleased to observe, that number one, this point too late in the day to raise the point of demur. On that, my lord, my very respectful response is, my points of demur are also, in a sense, point of merit. Why? Because, like, let us take an example.
That we appreciate, Mr. Please.
Take a hypothetical case. This matter is of immense public importance. One day the petitioner comes and says that no, I don't want to press the matter. But your lordships find that there is a public interest involved which should not be allowed to go away
Merely because the petitioner does not want
with the petitioner. Therefore, your lordship say that, sorry, sir, you are at liberty to step out of this litigation, but this litigation will remain alive. The court will proceed in the absence of the petitioner or even in the absence of any of the parties. The standards are so, what should I say, the strict in a sense and so loose in another sense.
The duty cast is very high.
Very high. Even in that case, take an example that your lordships have finally found without the petitioners that a particular religion has been favored.
Or the state action is especially arbitrary.
Yes. Now we are on the...
And has the effect of, causing prejudice to the populace of the state.
May I say this, Milord? Again, Milord, even on merits, Milord, there has to be a deprived class.
The state at large, the population of the state at large, 17% of the jobs going away.
Identified. But that is what a public interest.
Identified class?
Class.
The class of the state as a whole, we understand, is what is public.
Milord,
public word in the public interest litigation. Because, in fact, individual interest would exclude public interest automatically. Under 52 that you have argued, it can be made into converted into public interest litigation.
Definitely.
But even 52 we found is rather narrow and slightly it does not address the concept of public interest litigation as enunciated by the Supreme Court is some factors that are missing. So be that as it may. Please
Yes.
carry on.
Now, my lord, what I was saying is, my lord, even in the absence of the petitioner, my lord, there has to be an identified class for whose benefit a so-called bad decision is to be interfered by the court in the public interest litigation. My lord, my lord, consider it from a larger perspective. My lord, all bad decisions cannot be interfered unless, my lord, it is found that it affects somebody's right. Well, it is said a pill, PIL, is not a pill, PILL, for all diseases. So, so my lord, even on merits, even if your lordship does not consider my point of demur as a point of demur, and my lord, ignoring that also, my lord,
Yes. Yes.
therefore, my lord, there has to be an affected class, and in my humble understanding, an identified affected class. And, my lord, a PIL is ordinarily, my lord, not to, my lord, have the standards of an adversarial litigation. Seldom your lordships would find, but I in fact, my lord, have not been able to find out such cases where, my lord, a decision calls for or an adjudication, whether it's quasi-judicial, whether it is administrative, whether it is executive, whatever it is, calls for, my lord, adjudication, my lord, in the public interest domain. Therefore, my lord, a few more paragraphs, my lord, from this Sachar committee. But I was last at page number 201.
202. Empirical situation.
Yes. Empirical, I think I've finished empirical. Yes.
You were in the middle of paragraph page 203, National Sample Survey. 60+
Yes.
count.
That
What is
I,
that?
yes. But that I don't require. Now, kindly see, my lord. But there's a table at page 204, table 10.3.
Yes, please.
You know, the first column is state, the second column is population of 2001 in millions. Then where the third broad column is Hindus, the fourth broad column is Muslims. Now, kindly take where the second item, that is West Bengal. But in West Bengal, my lord, the population in millions was 80.2 millions. Then we are under the SC/ST percentage, your lordship would find, my lord, in 1999-2000, it was 43.3%. And in 2004-5, it was 42.0%. And the OBCs were 8.3% and 8.4%. As against that, my lord, the OBCs are 2.6% amongst Muslims in 1999 and 2.4% in 2004-5. Now, even, my lord, if your lordship considers my point of demur on merits, where none of these 8.4% OBCs, Hindu OBCs, have come up before your lordship and complained that my community or my class was required to be declared, it has not been declared. But this could have been an identified class.
Yes.
Nowadays, my lord, with the new laws coming, my lord, we cannot call a person by his class. The Chama cannot be called a Chama.
This was prevalent at least to a substantially lesser extent in Bengal.
Yes, yes.
Personally, it was a culture shock for me to go to the so-called home state, Andhra Pradesh. There was a culture shock for me. We are not used to caste.
No, casteism.
Casteism and classism, discrimination.
But casteism is very low in West Bengal.
In fact, successive Chief Justices of India who had come to Calcutta, I'm talking of let's say up to the 90s, have always raised a green flag in our favor. The only state where there is no caste issue so far.
Yes.
Now, my lord, therefore, my lord, what as an analogy, my lord, I have, my lord, resorted to this table 10.3, that even if your lordship considers it on merits, then also there has to be an identified class before your lordship coming and complaining that we have been deprived.
Yes.
Then we got 3 other pages and then I'm over. 2009, I'm sorry, 209, 10 and 11.
$209.
Yes. But I'll not trouble your lordship with these parts. Your lordship can skip over them. I don't place it because these are mostly on employment. Yes. Now kindly see, my lord, the concluding comments at page 213. 910 kindly, my lord. 213. 213.
Yes.
Concluding comments. As per the last round of NSSO survey, Muslim OBC constitute 40.7% of the total Muslim population. They are also a sizable component, 15.7% of the total OBC population of the country. The NSSO survey, however, fails to provide disaggregated figures across individual castes, groups included in the OBC list of the center and the various states. As a result, intra-OBC differentials along caste groups in terms of crucial indicators such as educational attainment and employment share cannot be estimated. The committee therefore is of the opinion that enumeration of caste groups as part of the decennial census exercise is critical to assess the equitable distribution of benefits meant for the groups included in the caste category OBC. The main findings about the economic and educational status of the 3 SRCs are summarized in table 10.13. It is important to underline that Muslims in India are not a monolith, and this is what our analysis across various indicators of human development also suggests. While while Hindu OBCs continue to be relatively deprived in terms of all India data, the Muslim community as a whole is lagging behind Hindu OBCs. However, overall, the conditions of the Muslim OBCs are worse than the Muslim general. The abysmally low representation of Muslim OBCs suggests that the benefit of entitlement meant for the backward classes are yet to reach them. And we're finally, Miller, please take page number 214, the second line. So this is again, Miller, a recommendation. The second group, that is the Ajlaf OBCs, need additional attention, which could be similar to that of Hindu OBCs. But there are various other parts, I don't think I need to.
Suggesting, Mr. Basu, that prior to 2006 and since 1947, Muslim OBCs, Muslims were never considered for the purpose of inclusion of OBCs at all.
That's what they say, abysmally low.
If they are backward, whereas 16.4 is, specifically says that religion cannot be a criteria.
Certainly.
So if Muslims have not been considered because of their religion, that's the only reason why they shouldn't be considered as have not been included as OBC. You've been including OBCs from 1950 onwards, all the way up to 2006, and Justice Rajendra Sachar finds in 2006 for the first time that
no, it was not in 2006 for the first time, but just before.
The Hon'ble Commission has been dealt with by Rajendra
Yes.
Sachar.
But what appears from this report, right or wrong, that up to a certain period, there was no, what should I say, no knowledge as such, or the socialists were not aware that OBCs are also amongst the Muslims.
So until 2006, according to that Sachar, because you're Muslim, you're excluded. Is that
almost like that? It appears to be that, or I put it in a different way, not in the negative terms. In the positive term, was that this concept was not prevailing, that OBCs could be amongst the Muslims also. The concept primarily was that it existed amongst the Hindus and not amongst the minorities, all minorities. This appears to be so. And that is why, your lordships would not find, or that is why there is very few Hindus, who have applied under this statute for declaration. Certain facts may have coincided.
Yes.
Announcement by the Chief Minister and then flow of applications or flooding of applications.
From primarily.
Yes. May have. The facts, I cannot dispute. I don't intend to dispute also. But, the facts which are said, please consider, giving the historical background. Are these facts so striking, bereft of the history and bereft of the past dealing with this Muslim OBCs, that striking, that electrifying, that the court should interfere?
What is most striking for us that it did not strike the commission to look into the Sachar committee report?
Yes. Sachar committee report.
Yes, please carry on, sir.
Yes. Sachar committee report, if I may put it in my humble understanding, is basically, collating history and facts.
Which is what a commission of inquiry is supposed to do prior to 93.
Yes. From there, we get these things, that these Muslims are, but there are various other studies also. I definitely think that there are other studies, but the gist, as I could understand from here, is that there are primarily 4 types, of which only one type is not the backward classes, but the others are all backward classes. Now, the backwardness or the level of backwardness differs. This is one part. The second part is that independent India was not conscious up to a certain timeline that there could exist OBCs among the Muslim also. Therefore, a large portion of the Muslim OBCs were undetermined as OBCs, and obviously they did not find place in either the central list or the state list. And the third aspect is that in so far as it was detected in various states, all did not go into the central list. These are, my lord, the broad three, my lord, what should I say, my lord, findings or gatherings, my lord, from this report.
Yes.
Now, my lord, the now, my lord, a few paragraphs from Indraswamy,
একটু ইংরেজ ইয়েটা দাও, জাজমেন্টটা দাও।
1992 supplementary 3 SCC 217.
Yes, para.
So the paragraphs are, please give me a moment. But there is a 9 judges bench, as your lordships know. 3 of the honorable judges had dissented. First is paragraph 31.
You had placed para 31 earlier.
But I have not placed, maybe the petitioners.
Free to repeat, no problem.
Yes. Yeah, but para 31 is what has been noted by in Sachar committee.
Yes. That you said that
Yes.
3184.
Yes.
341. 349, 481, 779, 782. You have referred to.
Yes.
And 174 pertaining to subjective satisfaction.
Yes. Now, this appears to be the parameters, under which, these kinds of declarations are to be made. Therefore, I don't trouble your lordship with Indraswamy anymore. Now, let us come to our affidavit in opposition. Where my learned junior prompts me to say that this is a host of petitions are before my lord.
Yes.
In all other petitions where affidavits have been filed, state and the commission had filed separate. But fortuitously, this is the one in which they have filed a joint one, and yes, and we are being ridiculed for that. Now, my lord, dear lordships, may kindly take a few paragraphs of my affidavit in opposition. I'm sure, my lord, my learned friends for the petitioners have placed it. May I please have a look to, my lord, paragraph, page 8. Roman 5 at page 8. The commission functioned within the ambit of law as embodied in the said act. The duties and functions of the commission have been depicted in section 9 and 10 of the act. The procedures followed by the Commission before taking any decision on recommending any class community for inclusion in the list of other backward classes for the state of West Bengal and also for rejecting any request for such inclusions inter alia are as follows. A. The class and or representatives of any class seeking inclusion in the list of OBC for the state of West Bengal are required to submit application claims in the prescribed proforma in which particulars such as names of the class, size of its population, its concentration in various places of the state, social, educational, matrimonial, occupational, and economic data information, etc. about the class are required to be furnished. The said proforma as received are then closely scrutinized by the Commission and thereafter public notice to all concerned, including the applicants, representatives of the respective classes who have signed the application, are issued for conducting a hearing by the Commission. All interested parties are invited to give detailed information and adduce oral and documentary evidence.
Can you pause for a moment, Doctor? Did you annex any document showing any advertisement or public notice or hearing?
Milord, what I intend to do is, Milord, we have it in Milord in a bunch. Milord, we have handed up copies to them also, but I'll hand up those bunch, Milord, and as a specimen, one of those, Milord, I'll place. But these are not, Milord, annexed to this. All interested parties are invited to give detailed information and adduce oral and documentary evidence in relation to the claim of inclusion of the respective class in the list of OBCs. It is specially mentioned that the Commission, in addition to the information as provided in the said filled in proforma, also take into account and consider other available records and statements, evidences, documents as would be ascertained in course of the hearing. Depending on the nature of the information as received, the Commission takes decision to conduct further hearing either in the Commission's office or in those areas where the people of the respective class are generally concentrated. The Commission, if required, also deputes its members and officials to conduct inquiry and to gather information on the classes seeking inclusion, and also visits the areas in which they are concentrated. The Commission, if required, also heard prominent members of the public having sufficient knowledge of the economic, social economic and educational background of the applicant class. The Commission also takes assistance of Cultural Research Institute, an expert body under the state government whenever necessary to gather detailed information on the applicant class. The Commission also calls for such documentary evidence from the applicant class that may justify their claim to be belonging to any particular class of the OBCs. The Commission, after having heard the representatives of the respective class and after gathering all the relevant information, evidence, etc., analyze and examines the same before finally taking a decision on recommending a respective class to the state government or inclusion in the list of OBC or its rejection. The Commission provides a full report giving detailed information to the state government when a decision has been taken to recommend a class. If a decision is taken to reject any such application, a report is furnished to the state government with full particulars. The West Bengal Commission for Backward Classes, being constituted in the year 1993 with the enactment of the West Bengal Act 1 of 1993, started functioning with its first meeting on and from 24th of December 93. In the years as referred to above, the Commission had considered those applications only which were submitted spontaneously by the representatives of the class. The Commission did not pick or choose applications for disposal, but disposed of whatever applications were filed with the Commission. Recommendation for a particular class thus depended on the incident of filing and subsequent disposal and not the religious identity of any class. Accordingly, the West Bengal Commission for Backward Classes had disposed of applications in exercise of powers conferred upon the Commission in Section 9 and 10 of the Act. The Commission has been discharging its functions to advise the state government in respect of inclusion of any class as OBC as spelled out in subsection 1 of Section 9 of the Act. The number of classes which has been included as OBC during the period 8 March 2010 to 24 September 2010 was truly included as per the recommendation of the Commission, duly supported by reports in consonance with the resolution of the Commission. Before 24th September 2010, there was a provision for 7% reservation in jobs for the OBC communities of West Bengal. Commission has so far not received any complaint against any of its recommendations for inclusion of any of the class in the list of OBC in West Bengal. Pausing here for a moment, Pilot. This could be also one of the points if your lordships decide the matter on merits, ignoring, Millard, my point of demur, that there is no complaint. Oh, I'm so sorry. But I think that I've skipped over it. Yes, yes, I'm so sorry. I'm so sorry. Yes. Millard, may I go back to Millard, page 11, the last slide.
Yeah.
The commission did not pick or choose applications. No,
After 7, after page 12, bottom, last 2 lines of page 12.
Yes.
Before 24th
Oh.
September.
No, I don't have page 13 with me. That's why. Yes. So, I'm sorry. May I start from the bottom of page 12?
Yes.
Before 24th September 2010, this proves how attentive I am.
Happens when the pressure is unmanageably high.
Therefore, before 24th September 2010, there was a provision for 7% reservation in jobs for the OBCs of West Bengal. This percentage of reservation was adopted in 1999 when about 15% of the total population was considered to belong to OBC. With many more communities having of late being identified as OBC, the population of the OBCs in the state has correspondingly increased from about 15% to more than 39%. In that perspective, reservation for OBCs required upward revision. In so revising, the view expressed by the apex court that reservation must not exceed 50% has to be duly considered. Recently, with recognition of 108 classes as OBCs, the percentage of reservation for the OBCs has been raised to 17%. The commission disposed of application as were filed before it in accordance with the provision of the said act based on the indicators relating to social, educational and economic status of the concerned class. The commission recommended any class as per strict provision of the act based on the indicators relating to social, educational and economic status of the concerned class. It is pertinent to mention here that the commission has so far not received any complaint against any of its recommendations for the inclusion of any class in the list of OBC in West Bengal. The commission holds public hearings before deciding on the matter of recommendation for the inclusion in the list of OBC, and anybody interested in the matter has scope to support or oppose such decision. The commission also deploys its members and officials to make inquiry into the claims made by the applicant class by visiting the areas in which they are concentrated. After observing total fairness, the commission recommends the class. The commission considered each application on its merit and after due completion of the process of law made its recommendation. It made its recommendation based on the social and educational backwardness and not on the basis of religion, secular, etc. Now, Millard, if your lordships may kindly take paragraph number 7, where we speak of Indira Swani. Millard, on the point of demur, where there's not much said, but there's some indication in paragraph 6 of my AO. The other threshold stage, Millard, threshold issues rather. The third line at page 3, para 6. It is denied that the petitioners have done any research work on the subject matter before filing the instant petition and prove the strict proof thereof. It is stated that the petitioners are neither any non-governmental organization nor any experienced body in the field of conducting a survey on historical development of a class and more particularly of backward classes. It is specifically denied that the provisions of the Act being section so-and-so and schedule so-and-so are fraud on the Constitution, and the same has been introduced. in a desperate bid to frustrate two writ petitions, etc. The assertion of the petitioners in regard to commission of fraud on constitution, but I've made my submissions on that. Then, my lord, at paragraph 7, the last 3 lines of that page is stated that having regard to the decisions of the Supreme Court, the state legislature enacted the act and the state government has been acting in compliance with the provisions of the act. Then, my lord, skipping a few lines, my lord, at page 17, my lord, please take the 8th line in paragraph at page 17. Paragraph 8. This paragraph 8. It is stated that time to time the commission has made recommendations to the state government and such recommendations were made after due inquiry. And in accordance with the said act, during the said period between 8th March 2010 to 24th September 2010, a large number of applications were submitted and each of them has been dealt with in accordance of its merit and by making due inquiry. The reservation of seats for backward classes is a matter of policy and a constitutional goal envisaged by Articles 15, 16, 29 and 340. It is pertinent to mention here that a large number of backward classes among the Muslim religious community did not earlier make applications for their recognition as backward classes. During the years 2009 and 10, among Muslim communities, 41 classes applied for recognition as backward classes. These applications were examined and duly considered by the Commission and necessary recommendations were made to the state government for enlisting them among other backward classes. Commission took time to decide on claims for inclusion in the list of OBC on merit of individual cases for which time required varied from case to case depending on the information received at different stages for disposal. It is again stated that all the applications for inclusion have been disposed of by the Commission by properly following the statutory provision of the said act and the rules framed thereunder. There is no significance, it should be, significance in either receiving or disposing of those 42 applications. Majority of the applications in the groups by Muslims is neither for the Commission nor for the state to explain. It is specifically denied that it is absurd, impossible, and beyond the capacity of the Commission to identify 42 communities within a period of 6 months as OBC community upon due compliance of the procedure. But these are all, my lord, denials. I don't trouble your lordships with all these. Now, please take, my lord, paragraph 9 at page 20. Three lines from the bottom of that page. As categorization is based on social, economic, and educational status, the entire OBC community has been divided into 2 categories. That is category A and category B. Out of the total population of 3.16 crore of OBCs in West Bengal, the more backward or category A comprises 55.6% of the total population, and the backward or the category B covers about 44.5% of the
Who
total.
is saying this, Mr. Doctor?
This the affidavit.
Member of the commission.
Yeah.
Whereas they admittedly they were not even consulted when the subclassification was being done.
No, this is the department saying. He is the assistant secretary of the backward classes welfare department.
Yes.
And how does this person have all these factors stated in para 125 true to his knowledge, Mr. Doctor? If at all.
It has to be on the records. Has to be on the basis of record. Has to be on the basis of record.
Show us the specific recommendation of the commission on the basis of which it was made. It has been referred to in awarding paragraph
yes.
that you have recommended. Where is that recommendation? Paragraph page 18.
On the documents inter se, my lord, or the documents, my lord, pertaining to the, my lord, from the date of application till the declaration, but kindly permit me to place these documents tomorrow. Let me have a look at it and come back tomorrow, my lord, because we have this matter fixed tomorrow also.
Yes.
Tomorrow I'll be finishing within half an hour or 45 minutes. And of course, my lord, I need to, my lord, distinguish the judgments, my lord. That will take me, my lord, another 15-20 minutes. Number, kindly permit me to, my lord, place this and then, my lord, this paragraph at page 21. Where the fourth line, when reservation of OBC was 7%, the total number of OBC segment was 15% of the entire population. Presently, 39% of the population of the state comprise of OBC. I further state that the categorization amongst the OBC is not unknown. This is a policy decision of the state government to ensure proper representation of weaker groups in reserved category, recognizing their comparative backwardness to achieve the object of reservation. It is stated that sample survey to determine the economic condition of backward community was entrusted to the study to the Center for the Study of Social Exclusion and Inclusive Policy, Department of Anthropology, University of Calcutta. The survey disclosed larger percentage of OBCs and more backward OBCs belonging to Muslim community amongst those newly 42 newly enlisted OBCs. It is stated that the assumption of the petitioner that the task was Herculean and 3 months were insufficient were not based on facts, and the statements are merely speculative, etc. Then, my lord, page 22, please take the last 5 lines. The government then brought out the notification of categorization of OBCs into category A and category B. It is denied that the government has any kind of ulterior motive, etc. Well, those are not important. Now, kindly take note that University of Calcutta study at page 31.
Can you explain this, Mr. Doctor? You have a commission, a full-fledged commission constituted under statute.
Yes.
Why did you have to fall back on a Calcutta University report?
Milord, this is, Milord, kindly see, Milord.
Commission not agreeing to your...
No, not that. Milord, we wanted, Milord, possibly. I should take instruction on this. Possibly, Milord, they wanted, Milord, a more specialized body who is, Milord, having the wherewithals. Wherewithals, Milord, I mean the intellectual wherewithals as well as the figure wherewithals to, Milord, assess this. Okay, please take me at page number 31.
Yes.
My lord, the first paragraph, please take the last 3 lines.
The report itself?
Yes, my lord. Page 32, the first paragraph over there, starting with the contrary directions, please take the last 3 lines. The Indian backwardness covers more than 30% of the population as a heterogeneous category, which consists of 3 broad divisions: scheduled caste, scheduled tribe, and other backward classes. That is Yadav something. Empowerment of the socially disadvantaged group, that is the scheduled caste and other backward classes, and the minorities continues has become a priority of country's development agenda. Their share in the country's total population is quite substantial, as scheduled caste account for 179.7 million, representing 17.5%, and minorities 188.9 million, representing 18.4% in 2001, projected on the basis of the trend of their decadal growth rates in the absence of data of 2001 census. The population of the OBC, as estimated by the Hon'ble Commission, constitutes 52% of the country's total population. It appears to be on a high side because of the possibility of certain communities of SCs and minorities featuring in the list of OBCs. A sizable Muslim population is also found in Uttar Pradesh, 25 million, West Bengal, 18 million, and Bihar 13 million. Now, these are the figures which has been gathered. Kindly now, Milord, skip over 3 pages. Please take, Milord, page number 35. Where the indicators are mentioned, Milord, in the previous first part of page 35. 35, no, 33, 35. Then we kindly come to the middle of that page. Separate weightage was given to the indicators of each group as different importance was ascribed to the indicators identifying socially and educational backward classes. As the social indicators were given a weightage of the 3 points each, the educational indicator weightage of 2 points each, and economic indicators a weightage of 1 point each. Moreover, only those caste classes which had a score of 50%, that is 11 points out of 20 in all, or above, were listed as socially and economically backward, and the rest were advanced. It gave support to the fact that not only social but educational and economic criteria were also included for the purpose of identifying OBCs regarding 192 socio-educational field survey. Moreover, position in the caste hierarchy was given 3 points out of 12 points in the social criteria and 22 points in all government of India. The caste classes or communities identified as backward was a result of this survey belonged to the Hindu religion and caste-based society only. But the scholar observed that a greater role to change the track of identifying backwardness communities in India, for example, the Sayyads and Sikhs are the priestly castes like the Brahmins, while the Mughals and Pathans, famous for their chivalry, are equal to Kshatriyas. There are occupational castes that are considered lower castes in the hierarchy. Thus, castes are hereditary names based on occupation, and there is a basic tendency amongst them to practice endogamy. They are descendants of the members of the Hindu clean caste who have been converted into Islam, either in group different caste or as whole castes. Groups from us. There is a notion of hierarchy amongst Muslims, though it is hard to say how far the criteria of ranking among them can be said to conform to the Hindu model. It is clear that caste exists as a basis of social relations amongst them, Muslims, but its form has been greatly weakened and modified as it differs from the Hindu model in certain details. Muslims are the followers of Islam. Kindly skip over that. Therefore, the Commission has to move beyond caste in order to form the basis of identifying socially and educationally backward section of non-Hindu population, and to evolve some other rough and ready criteria for identifying non-Hindu other backward classes. They are as follows: all untouchable converted to non-Hindu religion, and 2 is such occupational communities which are known by the name of their traditional hereditary occupation and where Hindu counterparts have been included in the list of Hindu other backward classes. For example, Nai, Teli, etc. Then will not kindly take page 37, last paragraph. The West Bengal government had not prepared any list of OBC till 93. In 1994, it prepared a list of backward classes on the basis of occupations in which social and educational backwardness is associated. It identified 60 castes and communities as OBC till 2003. Of these, 8 communities have been identified as Muslim OBCs. Total estimated OBC population in West Bengal is 1 crore 3 lakhs and odd. It means that the percentage of OBC population in West Bengal is 15.25% of the total state population. Total estimated Muslim OBC is 12,40,000 and odd, or 11.95% of the total state OBC population. Initially, the West Bengal government, in its notification dated 13th July 94, identified 14 castes as OBCs where no Muslim communities have been included in the OBC list. In another notification number so and so, Ansari Mumin had been included in the OBC list. Fakir Sain has been included in the state OBC list by the notification. Hawari were recognized as Muslim OBC in 95. Dhunia, Patidhar and Koshai were declared as Muslim OBC in 97. Notification, etc. Recognized Nasho Sheikh and Pahadia Muslims as the other backward classes. If we go through the ethnographic details of the arguments proffered in the present essay are based on the ethnological data incorporated in the Gallant Act 1984, Singh and Risley, that there are problems of identification of Muslim OBCs in West Bengal. It has already been mentioned that the state is the sole authority to classify certain sections of society as backward classes. So not only occupation, but also ethnic identity, social background of the communities and habitations must be considered as an important criteria for determining the Muslim OBC in West Bengal. For this, we need more ethnographic information about the communities. Otherwise, the politically articulate and organized community will get maximum benefit. The Muslim OBC as the disadvantaged group needs some special facilities to overcome their social handicaps, and for this we need proper identification of the detailed survey of Muslim OBCs in West Bengal. Therefore, my lord, in the West Bengal background, where your lordship would also find that we are from page 37 at the bottom, that those who were declared as OBCs, the majority were the Hindu OBCs. But out of 60 castes which were identified as OBCs, only 8 communities were Muslims. Or, my lord, the rest 52 were Hindu, other backward classes. Therefore, my lord, I was trying to emphasize that there could hardly be any complaint on religious factors if one notes the history. My lord, Mandal Commission, Sachar Committee takes note of the pan-India situation. This report takes note of the Bengal situation.
How much credence can we give to this report? It's a department of a university. What methods were employed? It's just like, possible that, a PhD degree, they are professional PhD thesis writers, for this purpose. In 2010, in the beginning, the state includes several classes. Second half of 2010, subclassifies it. Possibly, why wasn't the issue referred to a commission who maintains records in terms of a statute and things like that?
Yes.
So how can we cross-check with these people to their authenticity, their ability, their capacity? They are not accountable to anybody or anything. The state picks up a report as if it was prefabricated. Like as I was telling you, they are professional PhD thesis writers.
My lord, 2 things, my lord, your lordships have held. One is, my lord, there is always a presumption of validity of judicial and administrative works. But these are rebuttable. This has not been rebutted. This would be my first respectful response to your lordship's query. But my second response is, assuming for argument's sake, my lord, there is some evidence in rebuttal to this, assuming for argument's sake, then also your lordships have held that the court is not an expert of experts. Therefore, ordinarily, unless it is so strikingly imbalanced, my lord, I would be very respectfully submitting, my lord, in the absence of any rebuttal or any rebuttal evidence, because we are, my lord, in an Order 19 proceeding. Here, my lord, we do not have any oral evidence. So whatever are there, my lord, before your lordships by way of annexures and the petitions and applications are the pleadings and the evidences. Now, my lord, so long, my lord, nobody comes up and questions this, my lord, in my very respectful submission, my lord, ordinarily it should be accepted. Of course, the exceptions are there. Says
What we are asking you is the rationale or the thought process behind ignoring the commission, which is a statutorily constituted body, and picking up a department of the University of Calcutta and saying, taking their executive summary, that too. First thing, you are aware when the statute requires, or this dicta under Article 141, Indira Sani requires everybody, I mean, every state to consult the commission.
Yes, yes.
So that your job is more transparent and streamlined. Then why should you choose at all to go to this body? Whether you have a specialized statutory body under a statute passed by your own legislature.
Yes, yes.
This is what is bothering us. What is the
Very
thought
well.
process, Mr.
My lord, may I say this, my lord? Again, my lord, at the risk of repetition, I say, my lord, none of these things, my lord, has been controverted. Controverted. Therefore, my lord, please consider, my lord, apart from...
If at all it is acceptable, Mr. Dutta, controversy will come once, because there is no provision you are citing that you can take the help of such a research survey conducted by an independent authority. So that what fell from my brother, that how much of credence we can apply on this is not provided anywhere.
But may I say this, my lord, with respect? But had this point been argued by my learned friends, then, my lord, my respectful submission would have been, my lord, there is no vested right to a procedure.
There is no vested right to
a procedure. He cannot come and say that A, B, C, and D are the steps. You should have followed A, B, C, and D.
What
Yeah.
about the principle that with statute prescribes something to be done in a particular way?
Right.
You are supposed to do it under Article 141, the law declared by the Supreme Court is the law of the land. And thereafter you make specific codified law on that basis.
Yes. Now,
Body commission, and yet you choose nobody like an anthropological department of a University of Calcutta.
but, now, my lord, in the background of your lordship's query, let us look at the statute, my lord.
Yes.
Yes.
Please come to the statute.
When it's convenient for you, you use the commission. When it's not convenient, you use tomorrow. You'll use any local body reference.
No, my lord, it is it may not be a specialized body, but my lord, it is, say, Anthropological Survey of India.
Yes.
They may, yes, they may be on a higher footing. But please consider, can it be said that only and in every case is the Anthropological Survey of India is to be consulted? There may be other bodies which
What is the reason given by you not to go to the commission? There must be a reason that you went to this university.
No, I don't think there is any reason recorded subject to correction. I don't think so. But please, my lord, take, my lord, the statute, apropos, my lord, the query of the court.
Please.
Kindly comes to the statute at page 95, na? 99. Of the writ petition.
Section?
That section, where the definition section, Millet, section 2A, then 2C.
Backward classes and the list.
Yes.
Yes.
What is meant by backward classes and what is meant by the list. Then, my lord, skipping over a few sections, 3 and all, these are, my lord, the constitution of the commission. Now, kindly take, my lord, section 9 and 10.
Yes.
What can the commission do? It can examine requests for inclusion of any class as a backward class and hear complaints of over-inclusion or under-inclusion in the list and tender any advice to the state government as it deems appropriate. Then the advice, subsection 2 says the advice shall ordinarily be binding. Then 10 says that the commission, while performing its functions under the act, shall have the powers of a civil court, trying a suit in particular, summoning, etc. Then kindly take me 11. The state government may at any time and shall at the expiration of 10 years from the coming into force of this act and every succeeding period of 10 years thereafter, undertake revision of the list with a view to excluding such from such list those classes who have ceased to be backward classes or for including in such list new backward classes. The state government shall, while undertaking any revision referred to in subsection 1, consult the commission. But this is the only two relevant sections according to me. Then where it's the others are grant, and then we have section 17 in the rules, and then the difficulty clause is section 18, which I don't think comes into effect at this stage. Now, my lord, the statute which has been challenged, kindly have a look to that at page 147.
Could you explain, Mr. Dr., what was the purpose and object behind enacting this statute? You had the power under 16.4, there is a commission. You can declare, you issued notifications earlier.
I can issue, but there are two things, my lord. One is, my lord, identifying the classes, which is under this exercise, this act, and under 16.4 or 15.4, I can make special provision or reservations for these classes.
Correct. You did so before the act was 2012 act.
Definitely.
By executive order,
yes,
which you are empowered to do, in fact, under 16.4. You did not need a statute.
No, I don't need a statute to, my lord, make provision.
That's right.
Make revision.
Make the reservation.
To make reservation. But reservation in favor of whom?
Needed the 93 act.
But may I say this word, reservation for whom? Reservation for three types of classes. Scheduled caste, scheduled tribe, and other backward classes. Now, scheduled caste, scheduled tribe under those presidential orders, identified list is, my lord, included, excluded, castes and tribes are included.
Separate statute.
Separate statute. And so far as OBCs are concerned, my lord, each state have their own. We have this one, that is this act. Now, the object of this act is to identify. Kindly see, my lord, the preamble, not very clear, but kindly take page 49.
Yes, please. Page 149.
Yes, only 49.
Oh, 49.
Object.
Object.
49 of the
writ petition.
It says the procedure. একটা মানছে একটু দিতে দিয়ে এই ফর্মটা দিতে হচ্ছে হ্যাঁ 5 মিনিট একটু থেকে আমার একটু বুঝিয়েছি পেজ নাম্বারটা পেজ 99 Yes.
This is the 93 Act.
Yes.
We are not on this. We are on the 2012 Act. What was the object and purpose in because why
2012, yes, 2012.
Why we are asking you repeatedly, Mr. Dotto, is it's the definition of OBC in 2H.
Yes.
Of the 2012 Act.
Yes, but this is what, Miller, they have also impugned.
Yes.
or challenged.
This does not, the definition of OBC
Yes.
shall be in classes as special
So-and-so,
schedule one.
so-and-so includes such classes as the state government may by notification in the official gazette specify from time to time.
There is no mention of the commission recommendation, which means at first glance we get is you can recommend suo motu under section, under this definition and under this act.
May I say this, Milord? Identification under the 93 Act, list preparation under the 93 Act, and who are the backward classes for the purpose of 2012 Act is defined at 2H.
Does the 2012 Act save any provisions of the 93 Act or mention the Act?
No, it's not required.
Need not?
No, not required. Milord, may I read Milord 2H once more, Milord?
Yeah.
Other backward classes shall mean such classes of citizens as prescribed in Schedule 1. I'll come to Schedule 1 because that is also challenged. Other than the scheduled castes and scheduled tribe, and includes such classes as the state government may by notification in the official gazette specify from time to time. Because as for example, please take one notification. Please take Milord page number 139 as an example.
131.
139.
This is before the Act.
Yes, this is before the Act. Well, may I read it from the first line? Whereas backward classes have been defined in clause A of section 2 of the West Bengal Commission for Backward Classes Act 1993, so and so, for the purpose of the said act to mean such backward classes of citizens other than scheduled caste and scheduled tribe as may be specified by the government in the list. And whereas list has been defined under clause C of section 2 of the said act to mean list prepared by the government of West Bengal from time to time for purposes of making provision for reservation of appointments for posts in favor of backward classes of citizens which in the opinion of the government are not adequately represented in such and such. And whereas the government of West Bengal has decided to categorize the backward classes included in the lists into two categories depending on their relative backwardness and make separate provision for reservation in service and post in favor of the two categories. And whereas the government of West Bengal has conducted a sample survey to ascertain the relative backwardness of classes included in a list of backward classes, and the reports of the said survey has been duly received. Next line is very important. Now, therefore, in consideration of the report of the survey, the governor is pleased hereby to categorize the list of the backward classes notified for the purpose of the said act into two categories, such as category A and category B, wherein the category A would mean more backward and the category B would mean backward within the backward classes, and to bring the backward classes to so far enlisted into two categories, namely such and such. Now, this list, or this is one of those lists, which can be referred to identify other backward classes in section 2H.
This is subject to section 9 of the 93 Act.
Right.
That you have to go back to the commission.
Yes. Definitely.
That has not been done.
No, it has been done.
Where?
Well, there is no allegation that it has not been done. Tomorrow we have one sample case. I'll keep all the documents, but one sample case I'll place before my lords.
And any of the, let's say, the notifications under which the classes have been into the 42 first, 33 later. The notifications, or do they on their face at least indicate that the commission has recommended? They don't.
But I'll place those tomorrow. I'll place
those parts, huh?
Section 9.
একটা reference নিয়ে কাউকে reference করতে হবে।
পুরো প্রসিডিওর
Notification for the 42 and 33 classes.
Yes, yes.
Notification in 2010. No reference to the commission. Before that,
Everything.
Chief Minister's announcement, notification. Thereafter, everything was built up in the office. That's the first. That's what their argument is, and
But
that is what,
yes.
I mean, can't be thrown out. I'm not saying there is evidence to indicate that there was reverse engineering.
But as an example, take one of the recommendations of the commission, just as an example.
This in respect to which community?
This is in respect of Shikdar Muslim class. Just take note as an example, this one. It's in details.
It was placed, Mr.
Yes.
Not this particular community. Please go ahead.
Yes, this was the recommendation of the commission.
Yes, of the commission.
It's not disclosed, is it, Mr. Dr.
No. These are not disclosed. Then it would become voluminous. Kindly see the last paragraph. Section 9(1) is referred. ডিসক্লোজ করা যাবে দেখতে হবে তোমাকে যে গানটা দিয়েছি না ওটা আমি নিজে দেখি
There is no date in this recommendation.
Kindly see that one page ahead of whatever I have opened for your lordship.
Yes,
Where
one page ahead.
Yes.
Report of I am saying report of Shikdar Services.
There's 4 members of the commission, they don't put a date under their signature?
Yes, Mr.
But I'll satisfy your lordship that the procedure was followed. The commission was consulted. Commission's recommendations were taken. As your lordships were pleased to inquire, this was handy with me, but please take another thing.
They have inspected.
একটু দেখে নিও তো এটা ওদেরকে দেওয়া হয়েছে কিনা another thing just permit me this is for our purpose. Kindly take the sequence your lordship will get. The index shows the sequence.
Why should the commission give no? This is the procedure of the commission, isn't it?
No, it's Millard from the start of application till the Millard declaration.
By whom?
Commission.
But by various authorities. I just gave an
By the commission.
By the commission, I would assume.
Millard first. Yes, of
Yes,
course. Yes, by the right.
The second entry is notice to members of the commission to
Yes,
attend.
yes,
Very well.
yes.
Notice to Director Cultural Research Institute. This Cultural Research Institute is part of the Backward Classes Commission.
I have to check up. I have to check up. Millard, there are flags, Millard. Your Lordship will kindly, Millard, kindly take MS Millard. Please open the flag.
That's all right.
We have nothing to hide, Millard. Your Lordship, look into it.
No, we're glad you've been at least.
And this, I believe, Millard, the commission would be in a better position to, Millard, assist your Lordships.
Very well. It is only recommendation. হ্যাঁ
Request for the
চিঠিগুলো আছে ঠিক আছে
2017 থেকে
মিটিং যা হচ্ছে রিকোয়েস্ট সাপোর্ট একটা
this is only in this Shivdar. How do you?
Yes.
Yes.
Millard, may I stop here today?
Yes.
My lord, may we pray one thing, my lord? If anything is relied upon tomorrow, any document, additional document, a copy of that.
He will finish tomorrow. Any document, if he relies, he will give a copy to you. So that on the date of reply, you can come.
Because after me, the commission is to address your Lordship, sir.
কালকে তো order করা আছে তো?
Yes. Tomorrow the date is fixed.
Yes, order. করে দাও না।
Mr. Kishore Gopal and Advocate General has continued to make submissions on behalf of the state. The matter as ordered earlier tomorrow for further consideration.
No.
সেটা কি আগে যখন পজিশন তুমি করা যায়?
হ্যাঁ না
That order.
সমান